Selamat pagi semua.
Selamat pagi.
Pagi. Tuan Faizi, apa khabar?
Sihat Tuan, apa khabar Tuan?
Alhamdulillah.
Hari ni siapa seorang lagi kita punya ni?
Hi everybody, sorry for the hold up. I think I'm the last. I'm the last judge in, I think. So sorry. Let me just rename.
Hello, Assalamualaikum, and very good morning to all. Um, can everyone hear me?
Yes.
Right, thank you very much. Before we start, I would like to remind everyone to make their own technical checks. Please ensure your microphone, your video is turned on. Let everything is prepared. Thank you. All right, we shall start now. Yeah. All right. The session squad is now in session. Tuan Muhammad Ashar, Tuan Muhammad Faizi, and Puan Iza Haja Ahmad Izam is presiding. Thank you. The court is now in session. We call for case number STK 63 ES-E 6/6/2021. Prosecutor versus BEB is now in session. Please be mindful of your time as we will not notify you on your time management. Can the accused take the stand? The accused, please acknowledge the court.
Before we start, I'd like to point out a mistake in the bailiff's speech just now. This is not we are not hearing in the sessions court, and the case number is different. This is also not a criminal case. The plaintiffs are not we are not suing as a prosecution. We're suing as a plaintiffs, and we are representing Jaha bin Kabis and his community. And also the second plaintiff is Salib Anak Rumin as the second plaintiff alongside with his community in Long Curry. Is there any mistake with regards to the court setting, the quorum?
All right, unfortunately, the script given to me was a bit different. I would like to restart. I think may you please repeat the case number for me so that I could reinstate the correct case.
Yes, certainly. So our case number is SBW dash 22 NCVC dash 69 slash 1 dash 2022. And we are sitting in the quorum is currently set in Cebu High Court. And the plaintiffs are Jaha Kabis, suing for himself and on behalf of 258 natives of Long Burung Baru as the first plaintiff. And then the second plaintiff is Salib Anak Rumin, suing for himself and on behalf of 153 natives of Long Curry. And the defendants are, the first defendant is Borneo Electric Berhad. The second defendant is Awesome Social and Environmental Assessment Berhad. And then the third defendant is Minister of Urban Development and Natural Resources. The fourth defendant is Director of Economic Planning Unit Sarawak. And the fifth and last defendant is the State Government of Sarawak.
Maybe you can bring us back to the holding room, because if it's a high court and it's a civil suit, there's not three of us, there's probably one judge per room, which was what we were made to understand. I think perhaps there's an error here. In the meantime, I'll text Suhaila.
Can I give my input here? From my understanding, the proceeding is to be judged by 3 judges. We will do away with the procedural high court sitting as a single judge for the purpose of score sheet competitions. So all the 3 judges will assess the team individually, and the judges will come up with one decision, who are the winner and who are the first runner-up. So, but anyway, we can confirm this with the committee members. Is there a committee member here? No.
I've just Faizi, I've just spoken to Suhaila and she says she can confirm that that's correct. So if it's semi-finals, there'll be 3 judges. It's just that the factual, I think Bailiff just misread the factual circumstances. So it's not a criminal case; it's a civil case.
Yeah, it's correct.
Yes.
I think we all have the civil
Facts
case
before
scenario.
us.
Yeah, fact before us. It's just a slip. It's just a wrong script given to him, and there's no harm to the
Yeah,
proceeding.
so you can start. I think no issue, guys.
Yes, there's no issue. I think the judges are aware of the case scenario. We have read the case scenario given to us 2 weeks before. I think yes, I concur with my learned sister. We can proceed with the opening statement, perhaps, or maybe we can invite the first plaintiff to give their opening statements.
Yes, much obliged, Yang Arif.
Thank you.
Before I start my opening statement, so to give a brief introduction of our team members in our team. So my name is Lim Ching Ying, and I will be acting as the plaintiff's lead counsel. And together with me is Jaya Ganesh, who will be acting as the plaintiff's co-counsel. And PW1 is represented by Clement Hee Zhikang. PW2 is represented by Tan Boon Wee. And our instructing solicitor is Ms. Si Jia Wei.
Can you be kind enough to introduce the other side?
Yes, much obliged, Arif. So the defendant's first counsel is represented by Ms. Noor Najat, and the defendant co-counsel is represented by Ms. Noor Nisa Batrisha, and the first defendant witness is represented by Ms. Patzi Datu, and the second defendant witness is represented by Ms. Siti Nuranisha, and the defendant's instructing solicitor is Ms. Nur Liana Husdi.
Okay.
May I proceed, Arif?
Yes, please.
Yes. Before I commence the plaintiff's opening statement, in today's trial, the plaintiff would like to raise a preliminary objection in regards to the first defendant's bundle of documents. Yarif, according to the case scenario released by the organizer on 24th December 2021, it contained two maps, which are Map 1 and Map 2. And these two maps were subsequently revised by the organizer pursuant to their clarifications released on 5th January 2022. And these revised maps are contained in the clarifications common to both parties. And the revised maps are revised Map 1 and revised Map 2. However, if we refer to the first defendant's bundle of documents filed on the date of 28 January 2022, the first defendant have filed in the old maps instead of the revised maps. And subsequently, the plaintiff had also informed this error to the first defendant, and we have also addressed this error to the organizer. And this is done pursuant to a letter dated 31st January 2022. And we have also informed the defendant about our intention to raise a preliminary objection during trial. Arif, by filing the wrong maps, this shows that the first defendant is misleading the court today, and they are concealing important documents away from the court. Hence, we humbly request the court to expunge the first defendant's bundle of documents and to accept the plaintiff's bundle of documents as the common bundle of documents for both parties. And to support our preliminary objection, the plaintiff is relying on the case of IOI Lotus Crocklin Oil Sdn Berhad and LK Freight Services Malaysia Sdn Berhad, which is decided in the year of 2012 in High Court, where it was stated in that case that court orders must be observed, and the court is entitled to expect its officers to be more observant of that duty. And hence, since the organizer have released instructions regarding the revised maps, it is the duty of the defendant's counsel to file in the right maps in accordance with the instructions released by the organizer. And hence our prayer to expunge the first defendant's bundle of documents.
All right. That will be a basis for PO.
Yes.
Now, before we judges give our own view on that, perhaps we would like to hear a response from the defendants on this issue.
Sure, much obliged. Yang Arif, we have informed the plaintiff that we acknowledge the error. However, we already replied to the plaintiff that we believe it is upon the court's discretion whether to accept or reject those documents, as those documents are yet to be tendered as an exhibit. And we object to use the document as their document as the common bundle of documents, because the initial idea to bring each party to bring their own bundle of document was proposed by the plaintiff, and besides we had never got the chance to come into agreement in the agreed issue to be tried, the classification of the bundle of documents, because the recommendation that we have given from our side, we did not get any reply that or any negotiation regarding the bundle of documents. So the defendant humbly submit to use for each party to use their own bundle of document.
Okay, that will be all your response to the preliminary objections, defendant.
Yes.
Okay, plaintiff. I'm just curious. The revised map is made known to the parties, correct?
Yes.
All right. So you're objecting to the wrong submission of maps.
Yeah, Arif, our primary submission would be to expunge the entire bundle of documents because
Why?
Why? These two maps, by filing the wrong maps, it shows that the first defendant is misleading the court and they are concealing important documents.
I understand. So your problem is only with the maps, correct?
Yes.
Why do you want to expunge the whole document?
Yeah, Arif, our alternative submission would be to expunge the two maps only, but our primary submission would still maintain to expunge the entire of the bundle of documents on the ground that they are misleading the court.
Well, to be just to highlight to you, this maps has been given to you as well, correct? The revised map.
Yes.
So is there any prejudice caused to your side?
Yes, definitely.
Why?
The plaintiffs are prejudiced because by filing the wrong maps and relying on their own bundle of documents, by that this cannot show the full picture of the case. And those two maps are the wrong maps filed. It does not reflect the accurate situation of the project area of the Tagul Dam. It does not reflect the accurate picture of the case. Therefore, if the defendant is allowed to rely on the wrong maps and on the wrong documents, it will cause substantial prejudice towards the plaintiffs.
So, but they have acknowledged that there have been there was a mistake by their solicitors in their correspondence, correct?
Yeah, Arif, yes, they did email us and acknowledge their error. However, the first defendant...
To cut the matter short, don't you think this is a situation where the court can use order 2A rather than you want to stick to these minor issues, or you want to win on the merit?
Yeah, Arif.
Because both parties has acknowledged the mistake before coming to the court, and the revised map is being made known to both parties, and even we, the judges, also received the revised map. So do you think this an issue that we should be focused on, or we should go straight to the merit of the case? I mean,
yeah, Arif, then we shall submit on our alternative submission.
I mean, before we move forward, perhaps my learned brothers and sisters can give their input on this, because for me this is a mistake by solicitors. Of course, there will be we judges will see this at the end of the whole of submissions, but I don't see any prejudice or anything that can divert the focus of the main trial here. Tuan Azhar, Puan Izzah?
Yes, Brother Faizi, I agree. Let the witness testify what happened, which map is prevailed, which map is we are going to use. Let the witness testify.
Yeah.
Thank you very much.
I agree with my little brothers. I think there's no prejudice, guys. Everybody, we all know which map it is, so let's not raise unnecessary preliminary objections, yeah? So, I mean, we all know it's the revised map. It's been given to everybody. They've acknowledged the error, so we should have filed common bundles in the first place. So now, let's not argue about whose bundle supersedes the other.
Yeah. So on that note, plaintiff's solicitor, we unanimously dismiss your preliminary objection, and you may start your case. Okay.
Much obliged, Yang Arif. Yang Arif. May it please the court. My name is Lim Ching, and together with me is Jaya Ganesh, who will be representing the plaintiffs in the trial today. Yang Arif, the Tagul Dam project to the defendants is a profit-making machine which they are allowed to generate and trade electricity. However, to the plaintiffs, who are a group of underprivileged Orang Hulu natives, it means foregoing their cultural heritage and abandoning their ancestral land to give way to the Tagul Dam construction. And what makes the matter worse was when the plaintiffs were hit by 3 consecutive flash floods caused by the first defendant from the year 2019 until the year 2021. And the first defendant had refused to provide compensation to the flood victims. And this prompted the first and second plaintiffs' communities to collectively sue the defendants. However, only the first defendant had entered appearance on the plaintiff and served defense on the plaintiffs in our case today. And their defense was a bare denial of their liability, and they have failed to provide any justifications. As the second to fifth defendant had failed to enter appearance, the plaintiffs would like to put forward a request to this honorable court to enter judgment in default of appearance against the second to fifth defendant. Moving on to address the burden of proof in our present case, since this is a civil case, hence the plaintiff bears the burden to prove all the claims on the balance of probabilities. And in regards to the pre-trial bundle of documents, due to the extreme short notice by the first defendant and the stringent timeline, which is unnecessary and imposed by the first defendant on us unilaterally, the parties could not come to a consensus on the classification of documents. Hence, we have filed in separate bundle of documents. And in part A of the plaintiff's bundle of documents, it consists of map 1, dated 2010, showing the project area before construction, document 4A, press report from Borneo Sarawak Today titled Tagul Dam Causes Floods in Amansara, dated 21st January 2021, Table 1 on historical flood event at Amansara, Table 2, National Water Quality Standard for Sungai Burong and Sungai Ara, and Table 3, fish catch from 2011 to 2020 at Sungai Burong and Sungai Ara. While Part B consists of Document 1, which is the extracted parts of the Tagul Resettlement Action Plan, and Document 2, the brief overview of public consultations for the Tagul Dam project, Document 3, which is the Social and Environmental Impact Assessment Report, Document 4B, the press report from Borneo Sarawak Today titled Borneo Electric Berhad says Tagul Dam has saved the day amidst Kenyalang's climate change woes, dated 31st January 2021. And also lastly, map 2 dated 2020, showing the project area after the construction. And in our present case, in regards to the agreed facts, the parties have filed in a statement of agreed facts, and each parties have also filed in their own statement of facts. And moving on to the issues to be tried, there are 7 agreed issues to be tried. And the parties have also put forward their own additional issues to be tried before this court. And to summarize all these issues to be tried, this can be classified into 6 main categories. So we are dealing with issues related to native customary rights, right to property, and the issue of adequate compensation under Article 13 of the Federal Constitution.
I'm sorry, my lord. I believe, my lord and my lady, I believe we have to object with this agreed issue because we have come to agreement for issues by our own bundle of document, but these agreed issues is not what we have come to agree. I'm so sorry.
That's okay. These the issues. If you all can agree on the issue, that would be the ideal positions, ideal situations. But if you guys cannot agree on the issues to be tried, I mean, you guys can list down whatever issues from your own side. from your own angle. But ultimately, the focus of the case will be decided by the judges and so on. Okay.
Much obliged, my lord.
Reverting back to my opening statement, so the issues that we're going to try before this court today concern 6 main categories. So these 6 main categories are related to native customary rights, right to property, and also right to livelihood under Article 5 of the Federal Constitution, and also regarding the approval of the SEIA report and also the Tagul Dam project, and also regarding strict liability in respect of the 3 flash flood incidents, and lastly, relating to the breach of legitimate expectation. And this would be the issues to be tried before this court today. And in the trial today, the plaintiff is calling 2 witnesses in our present case. Firstly, Mr. Jahar Khabis, who will be acting as PW1, who will establish how his community was forcefully removed from their ancestral land in Long Burong and the subsequent challenges that his community encountered upon relocation. And secondly, Mr. Salib Anarumin as PW2, who will establish how his community was impacted by the construction of Tagul Dam project, yet he received no consultation from the first and second defendant. And in addressing the tried laws involved in our present case, the first and second plaintiffs' community are Orang Hulu natives recognized under the Sarawak Interpretation Ordinance 2005, and are entitled to native customary rights over Long Burong pursuant to Section 5, Sub 2 of the Sarawak Land Code. And also this is in accordance with the case of Director of Forest Sarawak and another, T.R. Sanda, Tabau, and others. And native customary rights are recognized as a form of proprietary rights protected under Article 13, Clause 1 of the Federal Constitution. Hence, if their native customary rights are to be extinguished, it must be done in accordance with law, it must be done for public purposes, and the first plaintiff's community must be provided with adequate compensation under Article 13, Clause 2 of the Federal Constitution. And when their native customary rights are extinguished, their right to livelihood is also affected. Hence, their right to livelihood under Article 5, Clause 1 of the Federal Constitution must also be taken into account when we are assessing the adequacy of compensation to the first plaintiff's community. And in regards to the 3 flood incidents, the plaintiff is relying on the doctrine of strict liability, and this can be established by proving the 3 elements stated in the case of Rylands at Fletcher, which include the elements of the defendant has brought onto his land something which might cause danger if it escapes. Second, this thing has escaped. And lastly, this thing has resulted in injury and damages on the plaintiff's communities. And in our present case, the defendant had impounded a tremendous amount of water in Tagul Dam. And the release of dam water had caused damage to the first and second plaintiff's community when the first defendant deliberately opened the dam gate and released the dam water into Sungai Burong. Moving on to the doctrine of breach of legitimate expectation. The plaintiff is relying on a case of Daraman bin Ibrahim and others, and Majlis Mesyuarat Kerajaan Negeri Perlis and others, where the court will consider 3 practical questions, which are, firstly, to what have the defendants committed itself, and have the defendants acted unlawfully in respect of its commitment? And lastly, what should the court do about it? And based on this case, the first defendant had misrepresented to the first plaintiff's community that their standard of living would be significantly better after relocation. And thereby, the first defendant had given a legitimate expectation towards the first plaintiff's community. And subsequently, the first defendant had failed to keep up with the promise that they gave. Hence, the first plaintiff's community is entitled to compensation for the breach of legitimate expectation. And in conclusion, the plaintiff would like to urge this court to find all the defendants jointly and severally liable for the plaintiff's loss and injury in the event the court agrees with the witness's testimony, along with the evidence tendered by the plaintiffs in this trial. This ends the plaintiff's opening statement. If
Right. Thank you, counsel. Just to clarify, so these are class action by two committees, correct?
Yes.
And the damages are direct. You are seeking for compensation.
Yes, Yang Arif.
As well as you ask for declaration, right?
Yes, that is correct, Yang Arif.
And you will be calling two witnesses to support.
Witnesses.
Yes, that is correct.
All right. Okay.
If I may be of no further assistance, the plaintiff shall now call upon the PW1 to the stand. Before I start the examination in chief for PW1, the plaintiff would also like to ask for the court's permission for our instructing solicitor to present her screen throughout trial to display the evidence tendered by the plaintiffs in today's trial. Mr. Jaha, please take the stand and take your oath.
Excuse me. Could we hear the defense case first? Now, what I mean, defense synopsis.
Opening statement.
Defense case.
I mean, from your from the order of the proceedings, as you all dapat briefing from the committee, how I mean, is this the order of the proceeding, or can we be flexible on this?
Yang Arif, according to the rules and briefing that we have received from the organizer, the plaintiff will first present our case and follow with examination in chief, cross-examination, re-examination for both plaintiff witnesses, and then it will be followed by the defendant's case with their opening statement, and then their examination in chief, cross-examination, and re-examination for both defendant witnesses, and then after that, both.
Okay, sorry for that. Okay. Please proceed.
Much obliged, Yang Arif. Yang Arif. Mr. Jaha, you may take your oath.
I, Jaha Kabis, with the IC number 660312131213, tag op, affirm and declare that the evidence that I shall give to the court shall be the truth, the whole truth, and nothing but the truth.
Mr. Jaha, what is your name, address, and occupation?
My name is Jaha Kabis, and I'm a fisherman who resides in Long Burong Baru.
Have you prepared a witness statement?
Yes.
With the court's permission, pursuant to Order 38, Rule 2 of the Rules of Court 2012, I would like the witness statement of Jaha Kabis to be presented.
Yang Arif, the first defendant would like to object the witness statement from both plaintiffs, as plaintiff has acted in a way above the court's authorities, as they already marked the document without the permission of the court. And given that the defendant has no room to object to the documents, and this has prejudiced the defendant's right to fair hearing, so thus we disputed page 11 of the witness statement 1 and page 10 of the second witness statement. I believe that the plaintiff has give us the script, not the witness statement. Thank you. Much obliged.
Yang Arif?
Yes, how do you respond to that?
Yang Arif, to respond to the defendant's objection, the plaintiff's position is that this witness statement is, the plaintiff has yet to read the witness statement, and according to the rules and according to the organizer, the witness statement is not taken to be read. And since the plaintiff has not finished reading this witness statement has not been tendered and marked until the end of examination in chief. Thus, this is not prejudicial towards the defendant's right to fair hearing.
Okay, objection overruled, I think, because for me, this is a statement prepared and it will read out as evidence. And then as far as if you go down to page marking of the exhibit, it should be done in open court.
Much obliged, Yang Arif.
Yang Arif, proceeding back to my to the examination in chief for PW1 Jaha Kabis, At question number 3, Mr. Jaha, what is this document?
This is the witness statement that I prepared.
With the court's permission, the plaintiff would like to request to read the witness statement for examination in chief. Mr. Jaha, why are you here in court today?
I'm a Sara Orang Hulu native. I'm suing on behalf of 258 natives of Long Burong Baru who relocated from Long Burong to Amansara to claim remedies from the defendants for the losses and damages we suffered from the relocation and flash floods caused by the first defendant due to the construction of Thagu Dam project.
What is the background of your community?
Prior to the year 1955, we were a nomadic community residing near Sungai Burong province. However, in the year 1955, some of our members decided to settle down in Long Burong by clearing virgin jungle, building long houses, cultivating food crops, and establishing burial grounds. In the year 1965, we established a permanent dwelling in Long Burong.
What was your main source of income prior to relocation at Amansara?
We largely remained self-sufficient as a community prior to resettlement by planting food crops, hunting, and gathering forest produce.
What is your relationship with PW2?
Objection, Your Arif. If the defense counsel may object that this question is a leading question.
And you have to establish first PW2 before you can suddenly ask what is your relationship with PW2. You must ask the witness.
Yang Arif, much obliged, Yang Arif. And on a side note, Yang Arif, according to the rules released by the organizer, when the first plaintiff's counsel is presenting, only the first defense counsel can object, and the second defense counsel cannot object.
That
in
one,
regards.
I know, but the one is too procedural. But
Yes.
their objection is
Leading question.
So how do you rectify this? You see, suddenly you ask the questions. What is your relationship PW2? Who are PW2? I mean, we judges also. Suddenly PW2 come into picture, right? Perhaps you want to rephrase your question, counsel?
Much obliged, Yang Arif. Allow me to rephrase my question.
You know already in your case study who are PW2. So you must establish who is she or he in our case. Is a colleague or okay?
Yang Arif, due to some technical errors with the instructing solicitor, we'd like to ask for permission from the court to represent the witness statement from PW1.
Okay.
Just proceed with the witness statement, please.
Much apologies, Yang Arif, in regards to technical errors. We are now at question number 6. Mr. Jaha, can you please answer your question? What was your main source of income prior to relocation at Amansara?
We largely remained self-sufficient as a community prior to resettlement by planting food crops, hunting, gathering forest produce, and fishing. We periodically track.
Arif, if I may object, we did not receive this copy of witness statement, as we only received the sixth question. It was answered with, we largely remain self-sufficient as a community prior to resettlement by planting food crops, hunting, and gathering forest procedure. We did not receive. We periodically traded our crops. Much obliged.
But we have that on.
Yang Arif, the plaintiff has served this witness statement to the defendant by virtue of our letter dated 4th February 2022. And the defendant does have a copy of this witness statement.
Proceed.
Much obliged, Yang Arif. Mr. Jaha, do you know Salib Anad Rumin, who is PW2 in our present case today?
Yes, I know him.
What is your relationship with PW2?
I know PW2 personally through trading activities between my community and PW2's community.
Is PW2 in court today?
Yes, PW2 is in the court today. He is the one wearing the orang ulu headpiece.
With the court's permission, the plaintiff would like to put on record that PW1 has identified PW2. Moving on to question 9. Mr. Jaha, can you tell us what happened during the construction of Tagul Dam?
I knew about
Objection, Yang Arif, this is a leading question.
Second, objection overruled. Proceed.
Witness, Mr. Jaha, you may answer the question.
Thank you. I knew about the Tagul Dam project during the consultation sessions organized by the first and second defendant in December 2010. We were informed that our community needed to relocate due to the impoundment of the dam. However, the consultation sessions my community received were lesser than the other directly impacted communities, Long Tara and Long Tagul.
With the court's permission, the plaintiff would like map 1 dated 2010 showing the project area before construction and map 2 dated 2020 showing the project area after construction to be placed side by side for comparison. Mr. Jaha, what are these two maps?
The map on the left is the map dated 2010 showing the project area before the construction of Tagul Dam. The map on the right is the map dated 2020 showing the project area after the Tagul Dam became fully operational.
What are the differences between these two maps?
In map 1, there is no Tagul Dam, while in map 2, the Tagul Dam, which is represented by a rectangular dam picture, has been constructed. After the constructions, we will lose our forests, burial grounds, residential area, and our culture. Furthermore, my place of residence had changed. In map 1, I previously lived in Long Burong, which is represented by a red spot with a cross on the map. In map 2, I have been relocated to Amansara, which is represented by a light blue spot with a cross on the brown color area of the map.
Mr. Jaha, going back to the witness statement at question 12, how was the process of resettlement?
The first defendant informed us that a compensation package would be devised to improve our standard of living, even though we have insisted on refusal to move. We informed the first defendant that we wanted to relocate to a place which was isolated and close to our burial grounds. The first defendant proposed 2 areas of resettlement, Kampung Melora and Amansara. Even though both resettlement areas could not satisfy our requirements, we were forced to resettle in Amansara. Our headman was forced to decide and give a verbal confirmation only in the year 2016, as dam was approaching its completion.
What were the terms of resettlement proposed by the first defendant?
We were promised that each household will receive 12 hectares of fertile land in Amansara, 900 ringgit a month for 3 years after resettlement, fuel subsidy for 1 baht per household, and compensation for loss of crops. The first defendant also promised us to provide reskilling for better employment opportunities.
Can you explain to the court what happened after the resettlement?
Our community finally resettled in Amansara in July 2017. We were given a concrete longhouse, but it was not big enough to cater to 258 individuals. We also had no knowledge or ability to expand the concrete longhouse to cater to more households.
Can you explain to the court what activities your community relied on as a source of income after relocation?
We attempted planting cash crops and food crops, but the land given to us was different from what we expected. The partly sandy land was unsuitable for crops. We also tried gathering forest produce in the forest nearby, but the forestry resources there were not plentiful. We managed to live relatively well by fishing until the decline of fish catch in September 2018. The fuel subsidy given by the first defendant to us was insufficient due to the longer fishing hours.
With the court's permission, the plaintiff would like Table 3, fish catch from 2011 to 2020 at Sungai Burong and Sungai Ara to be displayed to the witness.
Objection, Yang Arif, this is a leading statement from the plaintiff counsel, considering that plaintiff witness has not identified the document itself.
Yang Arif, in response to that, the plaintiff has yet to ask a question. The plaintiff is merely asking the court's permission to display table 3, which is this table on fish catch.
Yeah, proceed, moving on.
Mr. Jaha, what is this document?
This document displays the fish catch from 2011 to 2020 at Sungai Burong and Sungai Ara, recorded at Pekan Ara, which was provided by the Inland Fisheries Division of the Department of Agriculture, Sarawak. From the year 2018 to 2020, the fish catch of Ampura reduced from 190 kilograms to 101 kilogram and subsequently to 65 kilogram.
What were the other environmental impacts that you observed at Sungai Burong?
When I started fishing in the year 2017, the river was already polluted as I observed construction debris in Sungai Burong. In the year 2019, the pollution became more serious as the riverbed became shallower due to the increased sedimentation.
With the court's permission, the plaintiff would like Table 2, National Water Quality Standard for Sungai Burong and its tributary Sungai Ara from 2011 to 2020 to be displayed to the witness. Mr. Jaha, what is this document?
This document was obtained from the Inland Fisheries Division and it shows the National Water Quality Standard for Sungai Burong and its tributary Sungai Ara from 2011 to 2020. The water quality was at Class 3, polluted, and degraded to Class 4, severely polluted, from the year 2018 to 2019, and maintained Class 4, severely polluted in the year 2020.
With the court's permission, the plaintiff would like to display document 3, the key applicable points from the SEIA report. Mr. Jahar, what caused the erosion and also pollution at Sungai Burong?
The erosion and sedimentation was caused by the construction of a power station on a slope and the construction of 2 access roads on the either side of Sungai Burong, which both involve the cutting of slopes.
What did you do next?
After discovering the reduction of the fish catch and pollution, we lodged our dissatisfaction with the Tagu Orang Hulu Development Committee, the government officers in Pekan Ara, the village head of Pekan Ara, and fishery officers in Pekan Ara for the reduction of fish catch. However, no action was taken to resolve this issue.
Can you illustrate what were the repercussions after the decline of fish catch in Sungai Burong?
In January 2019, I decided to apply for a job in the first Defendant's dam facilities, oil palm plantation and logging industries. Unfortunately, I was rejected. I was informed that they prefer employing foreign workers due to low labor costs. Our lives become solely reliant on the subsidies given by the first Defendant. However, the subsidies given had lapsed in July 2020.
With the court's permission, the plaintiff would like Table 1, Historical Flood Event in Amansara from January 2020 to February 2021 to be displayed to the witness. Mr. Jaha, what is this document?
This table was provided by the Department of Irrigation and Drainage Malaysia. It shows 3 flash floods events that happened in Amansara from January 2020 to February 2021. During the first flood on 30th December 2019, our plantation were damaged.
How about the subsequent flood events?
The second flash flood happens on 15th December 2020 when the first Defendant opened the dam gates and released the water without any prior notice. Our longhouse was inundated with water for 3 days. Afterwards, we discovered horizontal cracks on the foundation beam of our longhouse and cracks in toilet facility. These structural flaws were confirmed to be latent defects of the longhouse, which were caused by insufficient foundation. Our personal properties and crops were damaged during the flood too as well. The third flood happened on 12th January 2021 and affected our newly replanted seedlings.
How did you recover from these 3 flash floods?
We received aid from various entities such as Pekan Ara Church, logging operators, and other civil society organizations, in particular Juara Burong, by erecting a temporary longhouse for us. Through Juara Burong, we were made aware of the existence of SEIA and track report and realized that we never had the opportunity to comment on the reports. Then we lodged a complaint about the flash floods to Tagul Orang Hulu Development Committee at District Office in Kampong Melora, but no response was received.
With the court's permission, the plaintiff would like document 4A, press report from Borneo Sarawak today titled Tagul Dam Causes Floods in Amansara, dated 21st January 2021 to be displayed to the witness. Mr. Jaha, what is this document?
This is the press report from Borneo Sarawak today titled Tagul Dam Causes Floods in Amansara, dated 21st January 2021. This press report was released by my community and PW2's committee with the help of Johor Burong due to our dissatisfaction on the resettlement package and lack of compensation from the first defendant in regards to 3 flash floods.
With the court's permission, this ends the examination in chief. The plaintiff would like PW1 to sign his witness statement before the court.
Okay.
Much obliged, Yang Arif.
Yes, I put my digital signature on the witness statement. Thank you.
With the court's permission, the plaintiff would like to mark PW1's witness statement dated 5th February 2022 as Exhibit P1.
Yang Arif, if I may object to the statement, considering that this table and the documents that has been shown are not, the witness is not the maker, thus I cannot, I believe that it should not be P instead, but ID. Thank you.
Yang Arif, in regards to the defendant's
The
objection,
defendant can cross the examination.
Yeah. I think the objection has no basis, like my learned brother says. You can cross-examine and you can submit on the value attached to the exhibits. Okay, objection overruled. Plaintiff witness statement to be marked as P1.
much obliged, Yang Arif. With the court's permission, the plaintiff would like to mark map 1 dated 2010 showing the project area before construction of Tagul Dam as Exhibit P2.
Okay.
Much obliged, Yang Arif. With the court's permission, the plaintiff would like to mark map 2 dated 2020 showing the project area after the Tagul Dam became fully operational as Exhibit P3.
Okay.
Much obliged, Yang Arif. With the court's permission, the plaintiff would like to mark document 4A, press report from Borneo Sarawak today titled Tagul Dam Causes Floods in Amansara, dated 21st January 2021 as Exhibit P4. Moving on to the next tendering of documents, the plaintiff would like to mark Table 1, Historical Flood Event at Amansara from January 2020 to February 2021 as Exhibit P5. Yarif, may I proceed?
Yes.
With the court's permission, the plaintiff would like to mark Table 2, National Water Quality Standard for Sungai Burong and Sungai Ara as Exhibit P6. Much
Okay.
obliged, Yang Arif. With the court's permission, the plaintiff would like to mark Table 3, Fish Catch from 2011 to 2020 at Sungai Burong and Sungai Ara as Exhibit P7.
Okay.
This ends the examination in chief for PW1, Mr. Jaha Kabis. Much obliged, Yang Arif. Yang Arif.
All right. So I now invite defendant's counsel to cross-examine the witness.
Much obliged, Yang Arif. Good morning. So now I'm going to put you some questions. So you are only going to answer me with yes or no unless stated otherwise, or agree or disagree. Is that understandable?
Yes.
How may I address you?
My name is Jaha Kabis.
Mr. Jaha, do you agree with me that you are not the maker for all of documents standard pre?
Sorry.
Hello?
I cannot hear you. Sorry. Can you repeat the question,
Okay.
counsel?
Do you
Your line is quite good, huh?
you are the maker for all of the documents? Oh, I'm so sorry. Can you guys hear me? Am I audible? Am I audible now?
Yes, proceed.
That's better.
Okay, so do you agree with me that you are not the maker for all of the documents standard previously?
Sorry, Councillor, may I refer to the...
No, just answer with yes or no. Do you, are you a maker for the documents?
Sorry, Councillor, which document are you mentioning?
All of the documents that are being tendered previously.
The witness statement, I'm the maker of the witness statement because I'm the one who...
Okay, just answer yes or no to the specific question that I asked. Okay, thank you. Do you agree with me that you have been staying in the Long Burung Baru since 2017?
Yes.
If I may refer to the witness statement question number 5, instructing solicitor, Miss Liana, can you please show the witness statement? Miss Liana? Okay. Number 5. Okay, so I put that the Orang Ulu community up.
The line is breaking again, Council.
Your voice is breaking.
In 1960.
Your voice is breaking. You may want
Yes or
to
no?
repeat the question again.
Yeah.
Orang Hulu community in 1960.
I'm sorry. Can you repeat your question again?
Okay. I put it to you that the Orang Ulu community took up permanent residence in 1960. Yes or no?
No.
Okay. Do you agree with me that the governments recognized the natives' right to customary land in 1958?
Sorry, Councillor, can you clarify your question?
Do you agree with me that the state of Sarawak recognized the natives' right customary land in 1958? Yes or no? Yes or no?
Sorry, Councillor, this question is a law-based question.
I am just asking, do you know the law that the natives' right customary land in 1958 that are being recognized? This is just a yes or no questions.
Sorry, Councillor, I do not know this.
Okay. I put it to you that you are not actually a native.
No, I'm a native.
Okay, just yes or no. Sorry. Sir, do you agree with me that you have been resettled to Long Burung Baru in 2017?
Yes.
Do you know Tuai Helang?
Yes.
Do you trust Tuai Helang?
Yes, he's our headman.
Okay, I just asked yes or no. Sorry. Do you agree with me that the options have been given for Tuai Helang to decide the area of resettlement?
Sorry, Councillor, can you specify your question?
Do you agree with me that the options have been given for Tuai Helang to decide the area of resettlement?
Yes, there are 2 options being given.
Okay, yes, I only want to hear yes. Do you agree with me that the resettlement area was decided by Tuai Helang?
Yes, Tuai Helang.
Do you agree with me that the reason why Tuai Helang chose Amansara is because it is secluded compared to Kampung Melora?
Sorry, Councillor, your line is breaking. Will you please repeat your question?
Do you agree with me that the reason why Tuai Helang chose Amansara is because it is secluded compared to Kampung Melora?
No.
I put it to you that you are not forced out of Long Burung.
No, we are forced.
Do you agree with me that there was consultation done?
Yes.
I put it to you that the consultation done is numerous times.
Yes.
Okay. Do you agree with me that there are 50 consultations met prior to the dam construction project?
Sorry, Councillor, I have no knowledge on 50 consultations.
Okay, just answer yes or no, or I don't know. So I put it to you that you have attended the consultation before.
Yes, I have attended few.
Okay, do you agree with me that you only attended 2 meetings only? Yes or
Council,
no?
can you specify which 2 meetings?
2 meetings prior to the dam construction project.
May I know when is the?
No, I'm just asking you, do you agree that you have actually attended 2 meetings for
Is
the among 50 consultation, only 2 consultation that was attended by your community?
So sorry, Council, can I ask further clarification on when is the consultation? Because there are some formal consultation and some informal visits by the representative.
Let me paraphrase my questions. So there are 50 consultations that was conducted. They are, I believe that from the statement of claim, your community has attended only 2 meetings only. True or not?
The sorry, Council, I would like to ask further clarification.
Okay,
when is the 2 meeting? Is it the
2 consultation?
Is it on 2011 to 2013 or 2014 to 2017?
Okay, the latter one.
The latter one is on 2014 to 2017.
Okay, let's just skip the questions. Do you agree with me that you have received compensation from BEB?
Sorry, Council, the compensation refers to the resettlement.
Do you agree with me that you have received the compensation from BEB, yes or no?
Council, I would like to further clarify
Did you receive the compensation for the resettlement package?
The witness, please answer the question. The question is very straightforward. Did you receive the compensation or not? You don't have to clarify. The job to clarify will be done by your counsel.
Did you receive the compensation?
I would like to ask the court that because the compensation refers, there are 2 compensation. It's either resettlement package or the compensation for after the second flash flood.
Which one, your defense counsel? Which one are you referring to?
The resettlement package. Do you receive the resettlement package?
Yes, we do receive.
Okay, yes or no? Yes, right? So I put it to you that you came to the court because you want more compensation from BEB. Yes or no?
Yes.
That's right.
Okay, yes. Okay, yes, counsel. Yes, witness. Do you agree with me that you have been planting wrong food crops on the land that was specifically for rubber?
No.
Okay, I put it to you that the outcome of the yield is your community's fault.
No.
Do you agree with me that the BEB has already informed you that the land is suitable for rubber plantation only?
No.
So, okay. Do you agree with me that you are a fisherman?
Yes.
Do you agree with me that the fish species are seasonal?
I have no knowledge on this.
Okay. Do you agree with me that you did not go fishing every day?
No, we do fish.
Yes or no? Do you go fishing every day or no?
Yes.
Okay. I put it to you that the decreased number of fish is not BEB's fault.
No, that's BEB's.
Okay,
fault.
yes. Okay. Do you agree with me that you are here today because you believe that the compensation was not enough?
Yes, the compensation is insufficient.
Okay, I just want yes or no. So I put it to you that the resettlement package is enough, but you didn't actually know how to manage it.
No, it is not enough.
Okay, just yes or no. My Lord Yang Arif, please warn the witness.
By your questions also, you have to be fair to the witness. Your question not necessarily requires a simple yes or no questions. So the witness must be allowed to express himself. Okay.
Yeah,
Moving on.
Moving on. Do you agree with me that flood is a natural occurrence?
Yes.
I put it to you that the flood was caused due to heavy rains.
No.
I put it to you that there was heavy rain in the Amansara area.
Yes.
Do you agree with me that the heavy rain is beyond the control of BEB's authority?
Yes.
That question should not be asked.
Yeah.
Do you know the concept of heavy fishing?
Sorry, Council, can you repeat?
Do you know the concept of heavy fishing?
No, we only know
I-
sustainable
that-
fishing.
I put it to you that there is no guideline on how to fish.
No,
I put it to you that since there is no guideline, your community are overfishing the area.
Arif,
no,
objection. The defendant is asking a leading question. The plaintiff has initially disagreed that there is a guideline on how to fish, and they are making an assumption that there is no guideline on how to fish.
Yang Arif.
Objection overruled. You can proceed with that line.
Okay. I put it to you that there is no proof to show that the cracks were caused by the flood.
sorry, Council. What? Can you repeat your question?
I put it to you that there is no proof to show that the cracks were caused by the flood in the Long Burung Baru.
No,
Do you agree with me that the cracks were actually caused by the residents in the community?
no,
I put it to you that the cracks appear before the flood.
no,
Do you agree with me that the flood was caused by water?
Of course.
Do you agree?
The nature of flood must be caused by the water, Council. It cannot be caused by air or
I'm sorry.
fire.
I put it to you that water cannot break the concrete.
no,
I put it to you that there is no proof that the flood water was caused by the crack.
You already asked this question.
The flood water caused the cracks.
You already asked this question, Council. Are you expecting a different answer?
Moving on. I
I'm
think
sorry.
you should move on from this line of questioning, Council. I think.
Okay, I'm so sorry, Yang Arif. Wait a I need a moment.
No?
I put it to you that there is no proof to show that there are inconsistencies in receiving the compensation.
yes,
I put it to you that the sedimentation was not caused by the flood.
yes,
Do you agree with me that you are just making an assumption based on your rough eyes?
no,
So, do you agree with me that you are actually making a malicious comments to direct the attention of the courts for today's case?
no,
Please submit on that.
Arif, objection. The defendant is asking questions imputing on the character evidence of the first plaintiff witness.
Please submit on that. Thank you.
Correct.
I'm sorry. Ms. Liana, instructing solicitor, can you please show question 21 of the witness statement? Question 22, I'm sorry. Question 22. Okay. Do you agree with me that you have planted the plantation?
yes,
Previously, you admit that there is no plant that can survive the land. Yes or no?
no,
I believe that is basically it from my cross-examination. Thank you.
Right, thank you, Council. So now we invite plaintiff's counsel to do re-examination on the witness.
Much obliged, Yang Arif. The plaintiff shall now commence re-examination for PW1, Mr. Jaha Kabis. Mr. Jaha, can you tell us about the status of your community?
we are the Orang Hulu. We are the native Orang Hulu. If I may refer to the clarification.
With the court's permission, the plaintiff would like to ask for permission for our instructing solicitor to display clarifications to the court.
I would like to refer to page 6, part C. Okay, thank you. So From the clarification, it is clearly stated that my community, we are Orang Ulu community, and we are the native community recognized under all applicable laws of Sarawak as being a native and thus subject to the applicable laws.
Witness, Mr. Jaha, moving on to my next question. So just now, when the defendant counsel asked you about the options being given to Tuai Helang regarding the resettlement sites, and you have stated that yes, Tuai Helang have received 2 options. Do you have any further explanation?
Yes, I do have. May I request to refer to the map 2?
With the court's permission, the plaintiff would like to ask for permission to display map 2.
As we have proposed the new setup, we have suggest reflected to the first defendant that we would like to have a site which is isolated and near our burial grounds. However, the 2 proposed areas by the first defendant is not correspondent to our request. And first, the Kampong Melora, which is the right, which is on the yellow spot there, is too far away from our burial grounds. And for the Amansara, which is the light blue spot across there, it is not isolated because there is another community nearby. So these are the 2 proposed area of resettlement to us, and it is not corresponding to our request. And Tuai Helang have to give verbal confirmation on 2016 because the dam is approaching its completion, and we choose Amansara there, the light blue spot, because it is nearer to our burial grounds.
Mr. Jaha, so just now you have also answered saying that you are forced out of Long Burong. Can you further explain about that?
We are forced out to Long Burong because the dam is approaching its completion and the impoundment of water is going to start. And our Long Burong is going to submerge in water. So we have no choice, but we have to relocate to Amansara, and which is the Long Burong Baru afterwards.
Mr. Jaha, you have also stated that you attended numerous consultations. Do you have any further explanation in regards to the consultation sessions?
Yes, I do attend the pre-consultations, which is way back on December 2010, inform us that our community is going to impact and convince us to relocate. And that's the first consultation that I have attended. Then the next consultation is on the Long Tara, which I went with Tuai Helang. And there is no SEIA consultation in Long Burong. They promised to give us a formal consultation. However, it has been cancelled due to the bad weather. And they promised to reschedule. However, we don't receive any consultation. May I refer to document 2?
With the court's permission, the plaintiff would like to display document 2, the brief overview of public consultations, to the witness.
Yes.
I would like to refer to the SEIA part. As from here, there are 4 consultations, 2 in Long Tara and 2 in Long Tagu. And there is none in Long Burong Baru. And sorry, there is none in Long Burong due to is cancelled due to bad weather, and there's no reschedule. So for our community, it is not fair to us because we receive inadequate consultations. And
Mr.
I would
Jaha.
like,
Mr. Jaha, do you have any further explanation in regards to this document 2 on the public consultations that you have received?
Yes, as compared to as referred to this document, we receive less consultation. As compared to the SEIF, we never receive any formal consultation. And for track, there is 20 consultation, 10 which were in Long Tara, 7 in Long Tagu, and 3 in Long Burong. We get lesser consultation as compared to another 2 communities. We receive inadequate consultation, and that's the reason that our needs and our requirement has not been fulfilled by the first defendant.
Moving on to my next question, Mr. Jaha. So earlier, you have also answered no to the defendant's question, saying that you are planting the wrong crops on the land. So do you have any further explanation?
Yes, we attempted to plant both cash crops and food crops. However, the sandy land is unsuitable for both crops. We do plant some cash crops on the partly sandy land. However, the produce is in low quality, and we only receive a little harvest, very bad harvest. Like for instance, we seldom get a corn with full kernel, and there is less grains in the paddy, in the hill paddy that we have. So that's the first about the food crops. And for cash crops, it is difficult for us to plant. So there are a few reasons. The first reason was we need more financial aids in order to plant cash crops, because we need money to buy the rubber saplings and also the fertilizer, but we never receive extra financial aid from them. And for cash crops, specifically rubber, as mentioned by the Defense Counsel just now, we don't receive sufficient training from the first defendant too. And as we know from the training, we need 5 to 6 years to cultivate rubbers to get latex from the rubbers. However, we only receive 3 years resettlement subsidies for the transition period, which is insufficient for us. So that's the reason that we attempt to plant both cash crops and food crops. However, there's no good outcome from there.
Mr. Jaha, you have also disagreed with the Defense Counsel, stating that the flood is not caused by heavy rainfall. Do you have any further explanation?
Yes, I would like to refer to Table 1. I would like to emphasize on the second flash flood, which is on 15 December 2020. This is the most serious flash flood that we encounter, and which the flood level is until 1.0 and 1.5 meter. The reason behind this second flash flood is the dam released the water, and we observe the water engulf from the upstream of Sungai Burong. They never give prior notice to us that they are going to release water. And that's the reason that our longhouse has been inundated in water. So from there, I can conclude that it is not caused by the heavy rainfall, but the release of water from the dam.
With the court's permission, the plaintiff would like to display map 2, showing the project area after the construction of Tagul Dam to the witness.
Now, hold on, plaintiff. This was not during the cross-examination, right?
Much apologies, Yang Arif.
It's not in the cross-examination, so you can't do this.
Much apologies, Yang Arif. Witness, do you have any further reasoning and explanation why you think the flood is not caused by heavy rainfall, but it is the...
Okay, there's another reason that leads to the floods, which is the cutting down of engaban trees, because to build the access road by the first defendant. Because of the cutting down of engaban trees, it leads to erosion, as we can see in map 2. If I may refer to map 2, that erosion.
Was this issue brought up during the cross-examination, counsel?
Yang Arif, it was asked by the defendant counsel to PW1. She specifically asked whether the flood is caused by heavy rainfall, and the witness is justifying why he disagreed with the defense counsel on his answer why the flood is not caused by heavy rainfall. May I proceed, Yang Arif?
Okay.
Yeah, okay. Thank you. I proceed. Then the erosion has caused the sedimentation at Sungai Burong there, which resulted in shallower riverbed, and it caused then it had leads to the water. The shallower riverbeds had lead to the water overflow. So these are the two reasons that the flash floods happens in our community.
Moving on to my next question, Mr. Jaha. So you have disagreed with the defendant's counsel on the guideline on how to fish. Do you have any, can you explain why?
Yes, we don't receive any specific document because we are illiterate. However, we have been taught by the PW2 communities how to fish, how to do sustainable fishing in Sungai Burong, so that we can have stable fish catch. So the first thing about the sustainable fishing was we are going to release the juvenile fish, and second, we are going to launch our fish catch in the Pekan Ara. So we are practicing sustainable fishing since we have been relocated there and since we have started fishing.
Moving on to my next question. So why did you disagree with the defendant's counsel that the cracks in your longhouse and also the cracks in toilet facilities were caused by the flood?
Yeah, it is. The floods has exacerbated the condition of the house. As previously, there is latent defects in the longhouse, which the first defendant used the low quality cement to make the concrete, and cause the concrete has less strength and it cannot support the whole house. So there are latent defects in it, and the flood has exacerbated the longhouse, and there are cracks, and we identify there are structural flaws on our longhouse.
So how did you know that it is a latent defect or structural flaws?
Is it consistent with your pleading, this line of questioning?
Yang Arif, we have pleaded in our statement of claim that there are structural flaws on the longhouse habitated by the first plaintiff's community.
So did you quantify the amount, the losses that plaintiff has suffered?
Yang Arif, the plaintiff is not able to quantify the losses and damages we have suffered because we are, for the purpose of this mock trial competition, we are limited with the documents released by the organizer, and the organizer has not provided any quantifications on the losses and damages.
Okay, thank you.
Much obliged, Arif.
Okay, I answered to my counsel previous question. So we knew after the second flash floods, we realized that there are structural flaws, there are cracks on the foundation beams there. So we asked Juara Burong, what's happening? Then the Juara Burong, they come and investigate on what is the reason of the cracks on the steels. And upon their investigation, then they realized that there are latent defects, and they told us the house is not safe, it's not stable to live anymore.
And also on one of the question by the defendant's counsel stating that you have contradicted, she alleged that you have contradicted yourself, because previously you answered that you could not plant anything on the sandy land, but eventually you said your plantations were damaged. Can you explain can you further explain on that?
Yes, as I have mentioned previously, prior to relocation, the planting food crops is our main. We plant food crops as our main subsistence. However, after relocating to Long Burong Baru, because of the land is not fertile, and we only managed to plant on some partly sandy land, we only managed to get low yields or the low qualities harvest from our food crops. We are only able to consume the crops, the food crops on our own, like some vegetables or some hill paddy. So that's for our own consumption. It's not for merchandise. It's not for sale.
Moving on to my last question for re-examination. Mr. Jahar, can you please explain how you obtain the documents that we have tendered during your examination in chief earlier?
My counsel, okay, after the second flash floods, the Johor Burong bring the Lim and Jaya associates to us, which is our counsel. Then I told the counsel what's happening to us. Then my counsel obtained all the documents from the departments or from the district office there. Yeah.
Can you specify how you obtain each and every document?
Counsel, this is not asked during the cross. You cannot reintroduce evidence through re-examinations. Okay.
Much obliged, Yang Arif. However, the defendant's lead counsel have asked the PW1 whether he's maker for all the documents that we have tendered during examination in chief.
Mm-hmm.
I mean, adding on to my little brother, counsel, clearly he's not the maker. So no matter what your explanation, it doesn't detract from the answer, does it? He's not the maker. So explaining how he got the documents still does not make him the maker, correct? So it doesn't really arise out of cross per se. And usually what would happen is that you would submit on the weightage of the evidence, it being a public document, whatnot, in submissions. It's not for the witness to testify where he got it from, right?
Much obliged, Yang Arif. This ends the plaintiff's re-examination for PW1 Johor Kabis. With the court's permission, the plaintiff would like to request for Mr. Johor Kabis to be released.
Yes, the witness is hereby released. Thank you, Mr. Johor Kabis.
Yeah, Arya.
Now, before we proceed with the calling of the second witness, PW2, I would like to invite my learned sisters and brother. We have since the proceedings of PW1, from our observations, we would like to make certain comments and observations so that both parties can improve further for the next witnesses and to ensure smooth running of our proceeding today. Okay. Can I invite Tuan Azhar first to just give tips, do and don'ts lah. Kalau tidak nanti Tuan, we're gonna have a lot of objections and whatnot. So yes, Tuan, please.
Thank you, Mr. Chairman. So when we talk about line of questioning and you want to get the answer yes or no, please be extra careful, because when the answer is not according to your line, you tend to disagree, and then you tend to use everything so that the witness will agree with you. Be careful with that. And then number two, please try not to confront with the witness. We are here to seek justice. And then if you confront the witness, so the argument will be going to be heat, and perhaps we can go for up to 4 o'clock. So be precise. Okay, thank you very much.
All right, thank you, Tuan. Puan Niza, perhaps some insight from you.
Right, I think after this, when you're calling the next witnesses, note counsels in examination in chief, you don't ask leading questions. If you don't ask leading questions, if you do ask leading questions, you can expect somebody to object to it. So maybe just avoid it altogether so that we don't descend into arguments for 15 minutes as to why something is leading and whatnot. It is unnecessary, right? Like my learned brother Tuan Azhar was saying, do not antagonize the witness. We are here to seek answers. So there's no purpose for you to be descending to an arguments to with the witness because, you know, the answers that they give does not match your expectation. So you take the witness's answer for what it is, and you work with that, right? Okay, be respectful to the witnesses. I know we're all lawyers, but because we are learned, we need to treat others who are not with some degree of, I suppose, respect. Okay, that's all from me. Moving on, please take note, yeah, councils. Don't want to hear all this again. Thank you.
Yes,
Thank
Your
you,
Honor.
Tuan Fauzi.
Thank you, Tuan Azhar, Puan Iza. All right. Yes, from me, I would
Mr.
say,
Chairman, one more, Mr. Chairman.
yes.
We
Pak.
are here to assess your advocacy.
Correct.
So if you ask the question yes or no, so we cannot assess your advocacy, right? Try to persuade the witness as much as you can so that you can win the case. Perhaps. Thank you.
All right. Yes, I would agree with that. The judges here are to assess your ability to question the witness and to respond to the judge's questions as well. Okay, so we are not keen with the correct proposition of law that much. But we would like to hear from you. We would like to see advocacies. We would like to see more intellectual discourse between the parties. We would like to see more interaction, more what do you call it, harmonized interactions. Okay, right. Okay, plaintiff, you may call your second witness, I suppose. Right.
Much obliged, Yang Arif. Yang Arif, my name is Jaya, and I appear before this court to conduct the examination in chief of the second plaintiff's witness, Mr. Saha. With the court's permission, we request the witness to take his stand and his oath.
My name is Salib Anak Rumin with the IC number 621007-13-1557. I hereby take oath, declare and affirm that the evidence I shall give to the court today shall be the truth, the whole truth, and nothing but the truth.
Mr. Salib, can you please tell us your full name, your address, and your occupation?
My name is Salib Anak Rumin. I'm a headman of Long Keri community who resides in Long Keri.
Have you prepared a witness statement?
Yes.
Yang Arif, with the permission from the court pursuant to Order 38, Rule 2 of the Rules of Court, we request the witness statement of Mr. Salib Anak Rumin to be presented to the witness. Mr. Salib, can you see this document before you? Is it clear to you?
Yes, it's clear to me.
Can you please identify this document?
This is the witness statement that I've prepared.
With the permission from the court, Yang Arif, we request the witness to read the witness statement throughout the examination in chief. Mr. Salib, can you please tell us why you're here in court today?
I'm a Sarawak native who is of the race of Orang Ulu. I'm suing on behalf of 153 natives of Long Keri to claim remedies from the defendants for the losses and damages we suffered due to the relocation of Long Burong Baru to Amansara and the construction of the Tagore Dam project.
Can you tell us about yourself and your community?
I'm the headman of Long Keri. Prior to 2005, we had been living in another area and relocated to Long Keri in 2005 due to agricultural development at our previous dwelling. After relocating to Long Keri in Amansara, my community had focused more on riverine fishing at Sungai Burong. The resources of the river were plentiful, and we were able to catch a variety of fish species such as ampurau, sema, tilapia, bawang, and patin. The ampurau species were found along Sungai Burong because they feed on the fruits of anggabang trees that only grow wild along the riverbank of Sungai Burong. We were also informed by the Sarawak Department of Fisheries again that the Sungai Burong is the last remaining haven for the ampurau fishes. We have also been trading with PWN's community prior to 2005 until now.
Does your community engage in other activities aside from fishing?
Yes, we planted some crops around Long Keri, but since the land in Long Keri is infertile, we mainly rely on fishing as our primary economic activity and subsistence. The crops we planted are not enough for our subsistence.
Mr. Saleh, do you know Mr. Jaha?
My apologies, Yang Arif. However, this is an leading question. Objection.
Yang Arif, if I may respond to that.
Yes.
Yang Arif, Mr. Jaha was earlier introduced to the court by the first plaintiff's counsel. Mr. Jaha has also completed his examination in chief. Since the court is aware of the existence of Mr. Jaha as the first plaintiff's witness, this is no longer a leading question.
Moving on.
Mr. Saleh, please answer the question.
Yes, he's in court today. He's the one wearing the Orang Ulu Selampai. I know him because we have been trading constantly prior to and after their relocation to Amansara in 2005. PW1 had traded their access food crops with our community as well.
Would you like to highlight to the court what happened in the year 2011?
In 2011, our community had noticed some official-looking individuals scouting around the vicinity of Amansara. They were wearing uniforms with the First Defendant logo on it. Upon inquiry, they told me that they are the workers of First Defendant and the scouting was done in anticipation of a potential resettlement of other community members on the neighboring land of almost 6,000 hectares in Amansara. They also told me that there is a plan to build a dam about 6 kilometers upstream from Amansara, which should begin in 2013. Since we were not given prior notice by BB regarding the dam and the longhouses construction, I raised my concerns to the workers. I was assured by the workers that dam construction will not affect my community and we do not have to worry about it resulting in any adverse effects in our lives.
What happened after this interaction with the workers from the First Defendant?
I felt worried because the relocation of another community at Amansara would lead to a starvation of resources. We barely have enough natural resources for our own self. I also felt that we should have been consulted regarding the Tago Dam construction and the resettlement of another community in Amansara, as both of these events would significantly affect the lives of people in my community. To make matters worse, from the year 2013, I observed construction waste and trash floating in the river. Around this time was when the Tago Dam was being constructed. The quality of water in Sungai Burong slowly started becoming worse from the year 2013, and this situation never improved. I told PW1 regarding this, and he responded that his community will be relocating to Amansara. He also confirmed with me that the First Defendant will be constructing a dam at the confluence of Sungai Burong and Sungai Tagol. He told me that he does not agree with the relocation as well.
Anything happened after that in Amansara?
In 2015, the construction of longhouses began, and this is where the community members from Long Burong will be staying. We raised our objections to the First Defendant construction workers. We informed these workers that the longhouses were being constructed without our consent or knowledge. After persistent objections from our community, the construction of the longhouses was briefly paused around 2016 and only to be resumed around 2017. The construction was resumed because representatives from First Defendant came to Long Keri and informed us that the natural resources in Amansara would be sufficient to cater the needs of our community and the new community. My community members were still concerned because we do not have enough resources our own self. The crops we grow only give us a low yield. Our fishing activities are only enough to meet our own demands. Having to share our land with another community will result in Amansara being starved of resources. The quality of the water in Sungai Burong also becomes considerably worse around 2015, and previously in 2013, the water quality was still clean enough for us to rely on, but now it was getting more and more polluted.
Can you tell us about the relocation of the community members from Long Burong?
In July 2017, the community members from Long Burong Baru arrived at Amansara. Upon relocating, the members of Long Burong realized that soil in their area was not suitable for planting food crops, and this eventually led them only yielding a small harvest. Thus, we taught the Long Burong Baru community members how to fish in Sungai Burong for the emperor fishes. We will record our fish catch at the fish landing site in Pekan Ara.
How did Long Borong Baru community members fare in Amansara?
The community members of Long Burong Baru would often face difficulty in traveling to Pekan Ara as they were reliant on the subsidies given by the first defendant, and these subsidies were not sufficient for them to make the journey to Pekan Ara.
Did anything happen after the relocation of the Long Burong Baru community members in 2017?
Around July 2018, the Engkabang trees along the river bank of Sungai Burong were being cut down by the workers from first defendant. The fruits from the Engkabang trees are the primary source of food for the emperor fishes, and this caused a direct reduction of the emperor fishes in Sungai Burong. This reduced our source of income as we were entirely reliant on the emperor fishes for our livelihood. The cutting down of the Engkabang trees also caused heavy sedimentation of the Sungai Burong. The river bank became progressively eroded, which led to the sedimentation of the river. Due to this, the other fish species also reduced in number. I observed a higher number of fish caught in Sungai Ara compared to Sungai Burong, and the reduced number of fish caught in Sungai Burong only worsened in year 2019 and 2020. This led to many young members of my community to leave Amansara and go to nearby towns to seek employment. I also observed workers from the first defendant at Sungai Burong installing silt traps at Sungai Burong. They perform desiltation every month. Despite these efforts, the effects of sedimentation in the river never improved, and the water was still very dirty.
What happened after that?
Seeing that our water supply from Sungai Burong and the fish catch has reduced to alarming levels, PW1 and I decided to lodge a complaint to the Tago Orang Ulu Development Committee. However, we have been ignored by the committee. Therefore, we lodged another complaint to the village head in Pekan Ara, Fisheries Department in Pekan Ara, and the district office in Kampung Melora regarding our grievances.
Mr. Saleh, if I were to show you the table depicting the National Water Quality Standard for Sungai Burong and its tributaries Sungai Ara from 2011 to 2020, would you be able to identify and explain its content?
Yes, I'm able to.
Young Arif, with the permission from the court, we request the instructing solicitor to display the table that shows the national quality standards in Sungai Burong and Sungai Ara. This was previously tendered to the court as Exhibit P6. Mr. Saleh, can you see this document clearly?
Yes.
Can you please identify this document and explain what it states?
Yes, the pollution in 2015 was caused by the construction of the dam where the debris was washed downstream in Sungai Burong.
Instructing solicitor, please scroll up to the question so we can see it. Thank you. Mr. Saleh, are you able to identify and explain the table showing the fish catch from 2011 to 2020 at Sungai Burong and Sungai Ara?
Yes, I can.
Young Arif, with the permission from the court, we request the instructing solicitor to display the table that shows the fish catch in Sungai Burong and in Sungai Ara, which was recorded at Pekan Ara. This table was previously tendered to the court as Exhibit P7. Mr. Saleh, can you see this document clearly?
Yes.
Can you please identify this document and also explain its content?
This table shows the number of fishes such as Empurau, Sema, Bau, and Patin reduced drastically from year 2018 to 2019 and from 2019 to 2020. However, only the number of tilapia slightly reduced from 2018 to 2019 and remained the same from 2019 to 2020. Comparatively, in Sungai Ara, the number of fishes such as Empurau, Sema, Patin, and tilapia increased from 2018 to 2019. However, the bawang species had slightly reduced in number. From 2019 to 2020, the number of the Empurau, Sema, and bawang had increased in number, and Patin remained the same. Only tilapia was reduced slightly.
Can you tell us about the flooding incidents that occurred in Amansara?
We experienced a total of 3 flooding incidents in Amansara in 2019, 2020, and 2021. Our community had encountered the first flood on 30th of December 2019 due to the heavy rainfall. The road in Amansara was inundated by the water and cut off from the outside community. Due to the first flood, some of our plantations such as paddy, tapioca, and other vegetables, amounting to a total affected area of 12,000 square feet, were being submerged in water for the whole night. Some of them were being washed away by the flood water. Similarly, complaints were lodged to Borneo Electric Berhad for immediate action, but to no avail.
Can you tell us what happened in the year 2020?
The year 2020 was the heaviest rain season ever recorded since we relocated here, and the second flood on 15th of December 2020 was more severe and remained for 3 consecutive days. During the second flood, our long houses were submerged in flood water that caused it to rot. Also, due to the wooden stilts submerged in water for quite some time, some of the wooden stilts were broken, causing the collapse of part of our longhouse.
Is there anything that you would like to add what you just previously stated?
Due to the flood, our burial sites were also destroyed. This is part of our cultural heritage and we lost it permanently. In addition, our fishing and farming equipment were also washed away due to strong current. Since we lost all our crops, we had to replant our crops by using the last remaining seedlings.
What can you tell us about the flood in 2021?
My community and PW1's community had requested aid from Tagore Orang Ulu Development Committee, local church, civil societies, and logging operators. However, we have not received any assistance from Tagore Orang Ulu Development Committee. Instead of that, we received aid from the Pekan Ara Church and the civil society organization known as Juara Burung. With the help of nearby logging campers, victims of the flood from Long Burung Baru, and our community members, we have built temporary shelters. My community and PW1's community had collectively written to the district office in Melora for assistance, and yet no response was received from them. After the flood, the civil society Juara Burung assisted PW1's community and my community to release a joint press release on Borneo Sarawak today on the 1st of January 2021 to call for immediate action from First Defendant. During the press release, we had raised our concerns and observations in Amansara throughout the years.
Mr. Salib, are you able to identify this press release that you just mentioned?
Yes.
Yang Arif, with the permission from the court, you request the instructing solicitor to display document 4A, which was previously tendered as Exhibit P4. Mr. Salib, can you see this document clearly?
Yes.
Now, please identify this document and also explain its content.
This is a press report that we released together with PW1's with the assistance of Juara Burung. And this report is about all the flooding incidents at Amansara. It also reports that the cause behind the flooding is due to the dam construction that leads to the sedimentation of Sungai Burung. It reports that despite the suffering of the people in Amansara, they only receive aid from a local church and civil society organization without the help of the real culprit.
Yeah, Arif, the plaintiffs have concluded the questions for the examination in chief. With the permission from the court, we request to mark PW2's witness statement as Exhibit P8. Young Arif, with the permission from the court, we request the witness to sign his witness statement. Mr. Salib, please sign this witness statement that you have written.
Yes, done.
Young Arif, that concludes the examination in chief. Much obliged, Young Arif, Young Arif.
Okay, now we invite Defendant's counsel to cross-examine the witness.
Mr. Black Sharif. All right. So, good morning, Mr. Salib Anak Rumin. How are you today?
Yeah, I'm fine. Thank you.
So, are you ready?
Yes, I'm ready.
All right, so now I'm going to ask you some questions. So you are only going to answer it with yes or no, agree or disagree, or I am not sure. Do you understand?
Yes, understood.
All right, so Mr. Salib, I put it to you that the witness statement is not prepared by you.
I disagree with you.
Yang Arif, I pray to the court to refer the plaintiff to the plaintiff witness statement. Thank you, instructing solicitor. All right. If we may scroll up to the first question. Instructing solicitor. Mr. Salib, I put it to you that this is a script for your counsel, not your witness statement. Yes or no?
No.
I put it to you that you have never met BEB. Yes or no?
Sorry, counsel, I couldn't hear you clearly.
I put it to you that you have never met BEB. Yes or no?
Met with?
BEB, the first defendant. Borno Electric Berhad. Have you witnessed?
Counsel, who are you mentioning specifically? I did aware of the existence of the
Okay,
worker.
it's just yes or no. Anyone from BEB. Have you met BEB? Any members of BEB?
Yes.
All right, so if I may refer to your answer in question 10, I pray to the court to share the screen. So based on your answer in question 10, I put it to you that you have never raised any objections regarding the Tagul Dam project, yes or no?
No.
So do you agree with me that you knew about the project in 2010?
I knew about the project.
Yeah, yes or no? Yes or no, witness? No. All right. Do you agree with me that you knew regarding the project through the press release made by BEB? Yes or no?
No.
Do you agree with me that you have resettled in Amansara in 2005?
Yes.
I put it to you that Amansara is a land owned by the government. Yes or no?
Yes.
I put it to you that you have no native rights over Amansara. Yes or no?
No.
Do you agree with me that Sungai Burong is the longest sungai in Sarawak? Yes or no?
Yes.
Do you agree with me that the river is used as a main route for the native of Sarawak?
Counsel, could you restructure your question?
I put it to you that the native living around Sungai Burong use the sungai as a main route for their transportation to anywhere they go.
Apologies, Yang Arif. The plaintiffs would like to object to that question on the grounds that this question was not raised during the examination in chief, and no other question in relation to this specification was also never raised during the examination in chief.
Question overruled. I mean, during cross-examination, you can ask questions.
Much obliged, Yang Arif.
Yes.
Yes,
So,
but
right.
That's not the only route.
All right. So do you agree with me that the river is, I put it to you that most of the Sarawak native live near Sungai. Yes or no?
I have no idea about that.
All right. I put it to you that there are many human activities near Sungai Burong.
Many what activities?
Human activities.
Human activities.
Indeed, such as the Tagul Dam.
Yes or no?
Yes.
All right. Do you agree with me that there are other projects upstream the Sungai Burong?
To be precise?
Any projects, anything?
Yes, we do notice some other
projects. Thank you. So do you agree with me that there are logging activities next to Amansara? Do you agree with me, witness?
Yes.
I put it to you that there are logging activities that can also lead to the pollution of the river water. Yes or no?
No.
All right. So you agree? Do you agree with me that you have a long-standing business relationship with the Long Burong communities?
Could you make it clearer, Council?
Do you agree with me that you have had business with the Long Burong communities before? You have a trade business, anything?
Yes.
All right. So I put it to you that you have enough natural resources to yourself since you can sell your fishes to Long Burong communities. Yes or no?
No, I disagree.
I put it to you that you have that you sell your access plan to Long Burong. Yes or no?
Council, could you repeat the question again?
I put it to you that you sell your excess plants to Long Burong, or your crops, plants such as crops and your paddy field and everything.
I only sell my fishes to the...
Yes or no?
No.
All right. So I put it to you that you are able to sell your fishes well after Long Burong Baru moved to Amansara. Yes or no?
Council, I couldn't hear you clearly.
Pardon me. I put it to you that you are able to sell your fishes well after Long Burong Baru moved to Amansara. Yes or no?
No.
All right. I put it to you that Ampurao fish is an expensive fish. Yes or no?
I disagree with you. I have no idea about that.
You have no idea. Okay. I put it to you that the profit from selling Ampurao fish can cost up to 1,000 ringgit per kg. Yes or no?
However, we are selling
yes or no only.
Young Arif, the plaintiffs would like to object to that question. The council is asking the same question twice when the witness has already clearly answered the question.
I did not question him the same question twice.
Let the plaintiff counsel finish.
Apologies, counsel. Please allow me to finish my sentence. Young Arif, this is a double question because the first question that was raised to the plaintiff is with regards to the price of the Ampurao fishes. And the plaintiff, the witness has already answered that he has no knowledge of that. And the subsequent question with regards to the price of that question is a double question, which is the same question repeating itself.
My apologies, Young Arif.
Witness, counsel, he's just putting it to the witness. The witness doesn't know, so she's just putting it to the witness. I put it to you that this is the price. So, of course, the witness can disagree, and we move on. Counsel, if the witness disagrees, you take that answer. You don't ask another question. And
All right.
Much obliged, Young Arif.
Okay, moving on. I put it to you that you have enough natural resources for yourself. Yes or no?
No.
All right. I put it to you that there may be outsiders fishing for Ampurao fish as well. Yes or no? Yes or no, witness?
I disagree. No.
All right. So does that do you agree with that your statement just now is indicating that the Sungai Burong is only for yourself to fish and no one else can fish at Sungai Burong?
That's not my intention.
All right. Do you agree with me that Ampurao fish is a seasonal fish?
I disagree with you.
Do you agree with me that Ampurao fish have a slow growth?
I disagree.
I put it to you that you have never researched on Ampurao fish, yes or no?
I'm a fisherman by my own self. I disagree with you.
I put it to you that the Sungai Burong is open to public and not the native only, yes or no?
Yes.
I put it to you that despite your control, you control your fishing amount as the answer that you state in your question 10, paragraph 2. If I may, if I humbly pray to the court to share the screen. All right. I put it to you that despite you control your fishing amount, the population of fish can also be affected by other factors. Yes or no?
Counsel, can you repeat your questions?
I put it to you that the rate of the fishes can also be affected by other factors. The fish population. Yes or no?
Yes, it would be caused by other factors.
All right, thank you. So do you agree with me that there can be seasonal changes in the population of the fish? All types of fish.
I disagree in my case.
All right, thank you. So I put it to you that you do not even know the basics of the emperor fishes or any other fishes in Sungai Burong. Yes or no?
No.
So I put it to you that your statement are based on your assumptions and allegations. Yes or no?
I've been staying in Amansara throughout the year.
Just yes or no?
No.
All right. I put it to you that you have never tried to plan anything in Amansara. Yes or no?
Sorry, couldn't hear you clearly, Counsel.
I put it to you that you have never tried to plan anything in Amansara. Yes or no?
I did plan in Amansara.
All right. So I put it to you that Amansara land is fertile since you are able to sell your excess plants to Amansara. Yes or no?
I disagree.
So I put it to you that the land in Amansara is fertile because you are able to plant in Amansara. Yes or no?
I disagree.
All right. And I put it to you that your daily activities focus on huntings and fishings. Yes or no?
Mainly rely on fishing.
All right. So I put it to you that your community has never observed the suitable tree to plant at Amansara. Yes or no?
I disagree with you.
I put it to you that you have never tried to plant rubber trees in Amansara. Yes or no?
Yes.
And I put it to you that Amansara is a land suitable to plant the rubber trees. Yes or no?
I strongly disagree.
I pray to the court to refer to the plaintiff in a statement for his answers in number 17. So I put it to you, as you mentioned here, that Amansara land is fertile since you are able to plant paddy, tapioca, and other vegetables.
That's misleading the court.
Young Arif, the plaintiffs would like to object to the question raised by the defendant's counsel. She's misleading the court. We did not state in the answer that the land in Amansara is fertile. That sentence that is highlighted only states that they planted paddy, tapioca, and other vegetables.
If Young Arif, if it's not fertile, they cannot even plant anything in the first place, Young Arif.
So
Counsel,
your
she's
question
just
to the witness,
asking.
yeah,
He's just asking. You can agree or disagree.
yeah.
You know, it's because of that statement. Would it that then the conclusion? You know, is it reasonable for us to assume? So that's the question. So if you disagree, then you disagree lah. Just answer the question, witness, and we move on.
Yes, disagree.
So, all right, thank you, witness. All right, so I put it to you that your answer is contradictory to the first plaintiff witness. Yes or no?
No.
All right. I put it to you that only Long Burong Baru made the complaint to BEB. Yes or no?
I disagree.
So do you agree with me that you have no proof that you lodged a complaint on BEB?
I lodged a complaint together with PWM.
Just yes or no? Just yes or no?
Yes.
All right. So I put it to you that your current living style is different compared to how you used to live. Yes or no?
Counsel, do you repeat your question again?
I put it to you that the current living style is currently different now. Yes or no? Your living style, the way you live in Amansara.
No.
Is it different? All right. So do you agree that most youngsters move out for more modernized working options? Yes or no?
Yes.
I put it to you that there are other economic options in Amansara. Yes or no?
There is, yes.
All right. And I put it to you that Amansara is near to various facilities. Yes or no?
Sorry, could you repeat?
Yes or no?
Amansara is near.
Yeah, it's near to various facilities, right? Is it? Yes or no?
No.
All right. So
what facilities, counsel? What facilities?
The clinics, the markets, and also school in Kampung Melora.
No, we need 30 minutes of boat drive.
All right. So I put it to you that the affected communities are those within 500 meters from the Tagol Dam project. Yes or no?
I disagree with you.
I put it to you that Long Curry is not situated within the 500 meters from the Tagore Dam project.
Yes.
I put it to you that Long Curry is located 6 km away from the Tagore Dam area.
Yes.
Do you agree with me that the Long Tagore is pardon me, I put it to you that all new resettlement areas are situated 6 km away from the Tagore Dam area, yes or no?
Yes.
Do you agree with me that BEB will not resettle the community in Amansara if Amansara is an affected place?
Council, could you rephrase your question?
Do you agree with me that BEB will never resettle the Long Burong communities in Amansara if it was to be affected, it is an affected party in the first place? Yes or no, witness?
In the first place, yes.
All right. Do you agree with me that the 3 km distance is safe since there are do you agree with me that the 6 km distance is safe since there are a 2 km embankment after the dam?
Strongly disagree.
Do you agree with me that Kenyalang experienced the highest rain of the decades in 2019?
Yes.
I put it to you that the rain is an unpredicted matter. Yes or no?
No.
Yang tu tak perlu tanya lah.
All right. Yeah. I put it to you that the Tagore Dam project has completed in 2016. Yes or no?
That one agreed facts kan?
Witness?
Yes.
All right. So I put it to you that water can never cause the crack on the brick. Yes or no?
I disagree.
I put it to you that bricks are harder than wood. Yes or no?
Yes.
All right. I put it to you that your wooden longhouse is damaged due to the material of the long was made not due to the flood. Yes or no?
No.
I put it to you that BAV offered aid after the flood to community of Amansara. Yes or no?
I disagree.
I put it to you that you and the first plaintiff rejected the aid BEV offered. Yes or no?
No.
All right, so I put it to you that you have no proof over the allegations you made.
Yes.
All right. Do you agree that you have never made any research on the river water yourself?
If the plaintiffs would like to object to that question, this question is unreasonable to ask to the witness because the witness is a native and aborigine within the state of Sarawak, and he's living in a community that has very low literacy rate, and therefore he's not the right person to be asking these questions.
Much apologies, Yang Arif. However, just now in the examination in chief, the witness stated that they observed the river as very polluted and there was debris in the river. Therefore, we have to ask this question, Yang Arif.
Yeah. Your question is what?
Do you agree that you have never made any research on the river water yourself?
Yourself.
The second plaintiff community.
Counsel, could you make it clearer? How do you define research?
All right. You have never made any critical observation on the river water?
I disagree.
Have you? All right. So I put it to you that if the water is polluted, all the fishes would have been reduced. Yes or no?
Counsel, could you rephrase your question?
I put it to you that if the water is polluted, all the population of the fishes in the river would have been reduced. Yes or no?
Yes.
I put it to you that the water is not polluted as the number of the tilapia fishes remains the same. Yes or no?
No.
I put it to you that the reduced number of other fishes is due to that other fishes is a seasonal fish. Yes or no?
No.
And I put it to you that there is a tendency for the fish to migrate from time to time. Yes or no?
No.
All right, so last question. I put it to you that you did not release the press report together with the first plaintiff. Yes or no?
No.
All right, Young Arif, that is all for our cross-examination. Much obliged, Young Arif.
Thank you, Defendant's Counsel. We would like to invite Plaintiff Counsel, second Plaintiff Counsel, to re-examine the witness.
Much obliged, Young Arif. Young Arif, I appear before this court again to conduct the re-examination of Mr. Salib. Mr. Salib, I have a few questions regarding the questions that were raised to you by my learned friend. Firstly, can you tell us about your relationship with Mr. Jaha? How do you happen to know him?
I knew Mr. Jaha because we have been constantly trading prior to my relocation in Amansara in year 2005 and after my relocation in Amansara. I've been trading fishes with his community in exchange for the crops which my community doesn't own.
Earlier, the opposing counsel, my learned friend, asked you, since you are trading with Mr. Jaha, that means you have an excess of resources. That means resources are enough for you. And you stated, no, you do not have enough resources. Can you please explain further on that?
Yes, the reason why is because the resources in Amansara is definitely barely enough for our own subsistence. The reason why we traded our fishes with Plaintiffs One's community is because we need to exchange for the crops that we are in lack of and we need for our own subsistence. This is because of the infertile land in Amansara.
Can you tell us, explain to us regarding the land in Amansara? And also, can you please explain to us the land in Amansara, the condition of the land in Amansara?
The condition in land of in Amansara itself is not fertile, and some of it is sandy. It is not suitable to plant rubber trees at all because rubber trees can't be planted on sandy land.
Could you perhaps explain further on how do you know that the land is infertile and what made you reach that conclusion? Can you please illustrate to the court?
The reason why is because we are constantly getting low yield from our harvest. We produce low quality crops from the land in Amansara. And that's the reason why I came to the conclusion that the land in Amansara is actually infertile.
Earlier, my learned friend asked you whether you have objected to the Tagul Dam. And could you perhaps explain to us all your objections, the objections that you made to the Tagul Dam construction from the inception?
The reason why we objected the Tagul Dam construction because it is located at the confluence of Sungai Burong and Sungai Tagul. And with that, it actually would affect the river condition and the fishes ecosystem in Sungai Burong. This is because we have constantly witnessing and observing waste being washed downstream to along Sungai Burong. That polluted the river, and also the cutting down of the trees to actually accommodate the powerhouse to generate electricity from the Tagul Dam had caused the erosion of the riverbank at the right side of Sungai Burong, and that leads to further sedimentation in the river. And that's the reason which leads to the reduction in all the fishes, mainly on emperor fishes, and that affects our livelihood. Other than that, it also affects our water source as we consume the water from Sungai Burong. And since pollution started in 2015, we need to venture to Pekan Ara to actually purchase mineral for our own consumption instead of using the water from Sungai Burong.
In relation to your answer, specifically with regards to the environmental effects, my learned friend asked you whether you are aware of the other projects and the fact that it might have an effect on the environment. Could you perhaps explain your answer with regards to that?
Yes, I do notice some other projects going on around the region of in Kenyalang, which is the hill resort and also the logging concession area. Council, could I refer to the map instead, to the map 2?
Young Arif, in order to assist the court further, the plaintiffs would like to request the instructing solicitor to display map 2, which shows the current state of affairs in the Kenyalang division. And this map is updated as of the year 2020. Witness, please answer your question.
Yes, I'm referring to the Hill Resort, which is located at the right side of Sungai Burong, and it's located on top of the mountain. And I'm also referring to the inland logging concession represented by the square in pink, and that is located inland. Both of these developments are far away from Sungai Burong.
Instructing solicitor, could you highlight to the court the locations that the witness just identified? Logging concession area 1 and logging concession area 2. You can perhaps drag your mouse cursor over it, or yeah.
Yes.
That will suffice. Is that what you were referring to just now?
Correct. I'm referring to the logging concession area 2.
Okay.
That is geographically further away to the Sungai Burong as compared to the build of access roads and the cutting of the Enkabang trees near the Sungai Burong. With that, it is impossible that the construction of the Hill Resort or the logging concession area 2 would have caused the sedimentation and the worsen effect in Sungai Burong.
Earlier, my learned friend asked you regarding your sale of Ampura fishes. And specifically, she asked you that the fact that it is very profitable and you could make thousands of ringgit. Could you explain to us your monthly income and perhaps also talk to us about your sale of Ampura fishes?
The main reason why I'm saying that the Emperor fishes is not that expensive in my own perspective is because we actually sold it to the market in Pekan Araf for low price, which is around 50 to 100 per kilograms. And we do notice that the Emperor fishes are rare, and that is the price that we have been selling to the nearby Pekan Araf marketplace.
Regarding Ampura fishes, can you please tell us what you know about Ampura fishes?
As stated in my witness statement, the Ampura fishes is actually rare and it feeds on specifically on the fruits of the Enkabang trees which grows wild along Sungai Burong, the riverbank of Sungai Burong.
Young Arif, we request the instructing solicitor to display map 2 so that the witness can point out the Enkabang trees that you just mentioned.
Counsel, could I refer to the first map instead?
Yeah.
Yes, for better explanation. Yes. As we can see the Enkabang trees along the riverbank of Sungai Burong from the right side, the riverbank is almost covered by the Enkabang trees, which is represented by the green dots. Yes. And the fishes, the Ampura fishes, mainly feeds on the fruits from these Enkabang trees. And as we refer to the second map.
Instructing solicitor, can you, on map 1, go back to map 1, please. The cursor that, the point at which the witness was specifying is the red, is the green cross next to Sungai Burong, not
Yes.
the green cross above. Okay, witness, you can continue answering the question.
Yes, as we can see, the riverbank was covered almost by the Enkabang trees. From the left side as well. And now I think we can refer to a second map.
Instructing solicitor, please scroll down to the second map.
Yes, as we can see the left side, the Enkabang trees were still in existence. But as for the right side of the Enkabang trees, they are all being cut down by the first defendant workers. And that leads to the reduction of our Ampura fishes because the main food source of the Ampura fishes, which they relies on, had been destroyed by the first defendant workers.
My learned friend has also asked you regarding the fact that whether you were affected by the Tagul Dam, since you're situated far away from it. And could you explain to the court why you're saying that you are affected by the Tagul Dam's construction and how you're affected by it as well?
The reason firstly is because of the building of the dam construction released the construction waste along Sungai Burong. That leads to pollution level in Sungai Burong increases, and that reduced or decreased the water quality in Sungai Burong. It affects our water source. Secondly, to accommodate the access roads leads to the powerhouse, which generates the electricity from the Tagul Dam. The first defendant workers cut down most of the Angkabang trees located at the right side of the Sungai Burong. And that leads to erosion and further sedimentation. As we can see from the map here, it was shaded in the orange line. The part where the erosion happened. That leads to sedimentation. And with sedimentation, the riverbed is shallower right now. And as the defendant released the inundated water from the dam during 2020, that caused the second flash flood in 2020. Because basically the riverbed is shallower, and our community was encountered and suffered from the flood as well. With that, it leads to the reduction of our fish source firstly, the damage on our longhouses, and also damage on our plantations, as well as our fishing equipments, which we could not rely on after we have encountered the flood.
You've told us extensively about all the damages that you have suffered. Can you please tell us regarding your complaints that you made to the...
Sorry, Counsel, this is not for you to... You have to re-examine.
Young Arif, the opposing counsel, my learned friend, asked the specific question whether he has made any complaints to BEB. That is the exact question that was asked. Okay. Asking him to illustrate on his
answer. What was his answer?
His answer was that he has made complaints.
Right. Then, what will be your next question to read?
My question to him is with regards to why did he make those complaints and to whom he made the complaints?
The reason that we made the complaint is because we have suffered a lot of damages from our longhouses, our plantations, and the fishes, which is our livelihood. And I have made the complaint together with the PW1's community through the assistance of the civil society named Jara Bureau. We made the complaint to Dago Orang Ulu Development Committee and also the first defendant, but they did not respond to our request and no aid was given at all. And with that, we only receive the assistance from the logging operators nearby and the community from the Long Burong Baru and also our own community members to build temporary shelters as we encountered the second flash flood.
Young Arif, that concludes the re-examination of the second plaintiff's witness, Mr. Salib. Much obliged, Young Arif. With that, we request the witness to be released.
Okay, thank you. PW2, we hereby release you from the stand. Yes, counsel for plaintiff, I believe you have closed your case, or did you still have any other witness to offer?
Young Arif, that concludes the examinations of all the witnesses that we have brought before the court. And with that, we would like to close our case.
Right. Before we move forward to the defendant's case, okay? It's been 2 hours, right? So perhaps we can take a recess for 10 minutes.
Much obliged, Young Arif.
Tuan Azhar, Puan Izzah?
Splendid, Tuan Faizi. Yes.
Thank you, Mr. Chairman. Okay.
Boleh 10 minutes, okay? We will reconvene at 11:40. All right? Okay, thank you, everyone. Thank you.
Thank you, Arif.
Waiting for the other two judges, okay? Done. All right. We're now in sessions. The court now in sessions. We would like to invite the defendants, first defendant solicitor, to give opening statements and to proceed with the calling of witnesses. Okay.
Much obliged, Yang Arif. May it please the Honorable Court, my name is Nonajat binti Baharudin, and alongside with me is my co-counsel Nurnisa Batrisha. We are acting for the first defendant, which is Borneo Electric Berhad BEB, registered with the registration number of 007-199-D. The plaintiffs asserted that the defendant was negligent and caused loss and damages suffered to the plaintiff. The parties have agreed to bring our own bundle of documents as we cannot reach an agreement during the pre-trial procedures. The defense team will be referring to document 1, document 2, document 3, table 1, and table 3 only. The defendant in this case is a company that is linked to the government, which is a company incorporated under Companies Act 2016 and fully owned by the government, which is the fifth defendant. The first defendant is the project proponent of Tagul Dam project, and the first defendant is responsible for the operation of the Tagul Dam at all material time. The Tagul Dam project was launched for the purpose of generating electricity located in Kenyalang division of Sarawak. It is one of the 12 dams identified in the Sarawak Corridor Renewable Energy, which needs to be completed by 2020 as part of the state and national plan to meet state and national energy needs. The Tagul Dam project will impact the Long Burung, Long Tara, and Long Tagul, and the relocation plan has been developed with consultation with the communities who are directly impacted from the project itself. Thus, by July 2007, 250 natives of Long Burung had resettled in Amansara as agreed by them. I will be explaining the alleged misconduct. Long Burung, which is the first plaintiff, claimed that the consultation process were lacking, and the second plaintiff claimed that the construction causes the changes in the sea hydrology and decline of fisheries, and the release of dam water in December 2020 to Sungai Burung due to the exceeding capacity of the dam caused floods to the plaintiff's area, and the resettlement package is actually insufficient for the first plaintiff. So in claiming under strict liability, the plaintiff must prove to the Honorable Court that the plaintiff must prove that the existence of a dangerous thing. The plaintiff also needs to prove that the defendant purposely accumulated the objects, and there is an escape from a place where the defendant has control and authority over to a place where the defendant has no control and authority over. The plaintiff needs to prove that the defendant makes a non-natural use of land and the damage was caused consequentially by the defendant's action. So in today's case, the defense will call upon two key witnesses, which is namely as the first witness, Alfred Sherlock, and the second witness is Juliana Abil. The first defendant did not owe any duty of care towards the second plaintiff, and the defense puts forward, among other matters, that the first defendant has fulfilled all the requirements and taken all reasonable steps as expected of a professional to ensure that the project is properly planned, managed, and executed so as to benefit the community. The first defendant's conduct was beyond their authority and to mitigate the risk during the flood for the common benefit of the plaintiff and the defendant. Thus, the first defendant's action for the resettlement plan to the first plaintiff was met based on what had been agreed and consent for the better quality of life of the first plaintiff. Thus, the defendant is seeking for the remedy, which is committed for the sustainable development to generate power over Kenyalang division of Sarawak, and the alleged misconduct was not even attributed towards the fault of the first defendant. Thus, the defendant humbly seeks from the Honorable Court that the claim will be dismissed with cause and reducing the interest of total judgment from 5% to 2.5% and dismiss the statement of claim and any other relief or order which is deemed necessary by this Honorable Court. With that, I end my opening statement.
So, defendant's counsel. So your defense, can you summarize your defense? What is your main defense?
So we are going, the defendant team will be using 3 defense, which is the act of God, and this is for the common benefit, and also for the statutory, the defense are not held liable over any misconduct, considering that this is under statutory, the defendant are protected under statutory authority. Much apologies.
All right. So this is your main defense, huh? All right.
Yes.
Okay, you may call your first witness.
If it may please the court, I would like to call the first witness to the stand.
Yes.
Good morning, Mr. Alfred. Are you ready?
Yes, I am ready.
Mr. Alfred, can you understand the English language or do you need a translator for the trial?
No, I understand English.
Mr. Alfred, do you prepare any witness statement?
Yes.
Miss Instructing Solicitor, can you please share screen? My lord and my lady, as we have submitted the witness statement prior to the trial, do you want us to go through it once again?
Yes, yes.
Mr. Alfred, can you please tell the court your name, age, and occupation?
My name is Alfred Sherlock. I am 60 years old. I am currently a project manager for Borneo Electric Berhad Tagul Dam, BEB. So I have been with BEB for 32 years and I have extensive expertise in facilitating and overseeing projects relating to the hydro dams and also the stakeholder consultation.
So, Mr. Alfred, what is your involvement with this project?
You know, I was directly involved with the Tagul Dam project, and in fact, I had led the Tagul Resettlement Action Plan Task Force, TRAP, as I was also the project manager for the project, and also the task force consisted of 6 individuals and multiple agencies.
Can you explain more about the Tagul Dam project?
Sure, the Sarawak state government regulates the Tagul Dam project to ensure all standards and legal standards are satisfied. So although controlled by the government, BEB operates as a business. So the Tagul Dam project is privately funded. The Tagul Dam is one of the 12 mega dam projects in the Sarawak corridor of renewable energy. So the hydro dams generate clean energy, which helps to mitigate the effects of climate change in the long term. So this part of the long-term goal for Sarawak and the nation to promote renewable energy industry in Kenyalang division and also the state.
What is the purpose of the Tagul Dam?
As I mentioned before, the Tagul Dam is one of the 12 dams in the Sarawak corridor of renewable energy core. So this must be built by 2020 to fulfill the state and also the national energy demand. So in brief, this Tagul Dam is a hydroelectric dam in Sarawak's Kenyalang division.
Okay, thank you, Mr. Alfred. Mr. Alfred, can you explain the size?
And then instructing solicitor, could you share with the witness statement, please?
Much obliged.
Thank you.
I believe we are in question 6. Okay. Mr. Alfred, can you explain the size of the dam?
So the dam catchment area is 450 kilometers square. So its undated area is 200 kilometers square. So the dam is 145 meter in height and also 445 meter in length. So this dam impounds the Tagul and also the Buruh rivers.
So when did the Tagul Dam project start?
The construction began in March 2013 and also completed in January 2018. The Tagul Dam began impounding in February 2018, but completely operational by December 2019.
Mr. Alfred, what is the guideline that you use for the project?
So Borneo Electric Berhad committed to embed and use the International Hydropower Association's Sustainability Assessment Protocol and also the IFC Performance Standard in its project development model. So the training of our project design and also project execution teams, which are the engineer, is the use of the two standard two guide issues around sustainability in our project has already commenced.
As the construction of the dam began, who is the affected individual?
3 Orang Hulu communities totaling to 1,200 people were identified as directly affected by the dam building and impounding of the Tagul and also the Upper Burong River. So BEB, we recruited a China-based dam IT construction and also the SEIA ASEA Consulting to conduct the social and environmental impact assessment. So in 2011 and 2013, the contemporary ethnography report and also a resettlement action plan was also developed. So the former also recorded that the number of the directly impacted person, their property, their land, and also their crop values, as well as their livelihood and also cultural tradition. So, this data, along with the early SEIA conclusion, went into the resettlement action plan also.
Yang Arif, this is an additional question. I would like to pray for the court to show the defendant a document.
Yes.
Instructing solicitor, can you please show document 2? Question, document 2.
I am now showing. Is it visible to the screen?
No.
No. Okay. Can the court give me a moment? Is it visible now?
Yes, thank you, Miss Instructing Solicitor. Mr. Alfred, can you please identify this document?
Yes, this is the contemporary ethnography study.
Yang Arif, the witness has identified the document, and with that, we would humbly pray for this to be tendered as exhibit. Since the maker is not here, we would like to be tendered as ID instead.
All right.
Much obliged, Yang Arif. Okay, moving on to the next question, Miss Instructing Solicitor. Can we go back to witness statement again? Okay. Mr. Alfred, can you explain more about the preparation of development of the resettlement action plan?
Sure, the REP preparation and execution alone required hours of consultation with directly impacted communities. So including over 20 formal and also 20 informal consultation sessions. So during the pre-REP consultations process, the BEB briefed the directly impacted community people about the planned project and also its consequences. Members of the community were also consulted about their preference for relocation places. So despite their opposition to relocation, the communities indicated that they want to stay near to the river they call home. So Long Burong residents, the most remote of the 3 impacted towns, said that they enjoy the isolation and preferred a less crowded environment. So following this, 2 main areas were identified as the prospective resettlement sites, which are Amansara, about 6 km downstream from the Tagul Dam project, and also Kampung Melora, a small and growing village on the outskirts of Melora town.
Mr. Alfred, when did Long Tara and Long Tagul relocate to a new area?
So by early 2017, the Long Tara and Long Tagul communities had been successfully relocated to Kampung Melora. And the communities now enjoy access to facilities such as schools for their children, clinic, church, and also the market.
Where did the Long Burong community resettle?
After some initial reluctance, the Long Burong community was willing to move and choose Amansara. So while not as accessible to amenities as Kampung Melora, Amansara has easy boat access to nearby Pekan Ara. So Pekan Ara is about 4 to 5 km away. So based on the RAP analysis, Amansara was likewise rated equivalent in terms of crop culture potential and resources richness.
What is Tagul resettlement action plan that was set upon the 3 Long?
The comprehensive relocation plan for the Long Burung communities to Amansara included new concrete housing with diesel power, a monthly subsidies of 900 per household for the first 3 years to ease the transition and enable substances, and also 12 hectares of land per household for crop cultivation, fuel subsidies for 1 boat per household, and also compensation for loss of crops at the time of the resettlement.
Yeah, Arif, this is also an additional questions. I would like to pray the court to show the defendant a document. Yes, document 1. Can you please show document 1? Okay. Mr. Alfred, can you identify this document?
Yes, this is the Tagore Resettlement Action Plan that I made.
The witness has identified SE.
Your voice.
Much obliged. Much obliged, Arif. Mr. Alfred, how has the relocation affected the living condition of the Long Burung community?
So the relocation plan enhanced the life of the Tagudem impacted communities. In Long Burung, while the community looked self-sufficient, there was no access to emergency medical treatment or even education for the children. So the living conditions were also very poor, with trash, dog, and even chicken waste covering the courtyard and living areas. So also fewer than 5% of the community was literate. So the neighbor was likewise poor, with monthly incomes of less than 50 ringgit per home. So fortunately, the relocation of Amansara provided healthcare access, markets, schools, and also job opportunities. So as these are part of its ongoing corporate social responsibilities, these PEB designated facilities for all the relocation settlements, including the flush bathrooms, the community recreation areas, and also the women empowerment programs for the women.
Mr. Alfred, can you tell us what bring you to the court today?
It's concerning the flood in Amansara in December 2020 and January 2021. Sarawak and Kenyatlang recorded the highest rainfall in those 2 months. So the constant rain in December show climate change, as we are seeing increased rainfall intensity, thunderstorm frequency and duration, and more wet days per year. So this trend has been rising since the end of 2018. So in December 2020, heavy rains increased the water levels at the dam. And because heavy rains were forecast throughout the month and into January, we had to release the water from the dam. So this is normal practice, and we do not believe that it is the sole and real cause of the Amansara flood. So the catchment area and also reservoir acts as the flood measure control. So we believe that without the Tagul Dam, Amansara, and even other communities downstream would have been flooded worse.
Yeah, Arif, this is all an additional questions. I would like to pray the court to show defendant a document. Ms. Introducing Solicitor, can you please show us table 1? Okay. Mr. Alfred, can you identify this document?
Yes.
Counsel, is this the same documents that the plaintiff had tendered, or is it different documents?
Okay. The witness has identified this document. Yeah, this is the same document.
Okay.
The witness has identified the document. With that, we would humbly pray for this to be tendered as ID also. Okay, much obliged, Arif. Mr. Alfred, no need to.
Like my learned brother just mentioned just now, this has been tendered before, so no need to tender.
Much obliged, Yang Arif.
Sorry, my
Mr. Alfred.
Please turn off your handphone.
Sure. Sorry, Ma. Sorry, Arif, sorry.
Mr. Alfred, I'm sorry. We are sorry for the inconvenience. What did BEB do after the disaster?
So following our investigation into the flood in Amansara, we offered to provide support to the two Amansara communities in order to repair all the property damage. However, this offer was turned down by the communities.
If there is no more further amendment, then I would like to sign the witness statement. May the court tender the witness statement.
Yes.
Mr. Alfred, are you also a native?
That I am my EIC and pass.
I'm not a native.
With the court's permission, the plaintiff shall now commence cross-examination against DW1, Mr. Alfred Sherlock.
Yes, please.
Good afternoon, Mr. Alfred. I have several questions for you today. So firstly,
yes.
I would like to ask Mr. Alfred, so are you aware that the first plaintiff's community are natives?
Sorry, I cannot hear you clearly. Your voice quite slow. Is it? Or is it just me?
Mr.
Yeah,
Alfred,
I'm so sorry.
Mr. Alfred, are you aware that the first plaintiff's community are natives?
No,
You're not
they
aware.
are not native.
Okay, thank you.
Yeah.
Thank you. So referring you to document 1, which you have tendered as ID1 previously, the trap report, with the court's permission, I'd like the instructing solicitor to display document 1 at the part of the communities. So this is the trap report that your task force has prepared. Is that correct?
The trap, is it the trap?
Witness, I only need a precise answer. Is this trap report the trap report that your task force has prepared?
Your what? Can
Your
you
task
simplify your
force.
question?
Is this trap report prepared by you, your task force, by the first defendant?
Yes.
Yes. So I refer you to the first paragraph. I refer you to the last sentence. All 3 communities are of the Orang Hulu indigenous group. Do you agree with me on that statement?
The first paragraph.
The last sentence.
The last sentence.
Yes. If I may quote in verbatim, it states that all 3 communities are of the Orang Hulu indigenous group. Do you agree with me on that statement?
I agree, but I don't know the story.
I don't need your explanation. It's okay. You can address it later during your re-examination. So furthermore, referring you to paragraph 4 of this part, yes. So you have also stated that the Orang Hulu communities have only taken up permanent residence at the 3rd line and begun cultivating food crops.
Can you zoom in a bit, because I have a poor, I don't know this laptop thingy.
Definitely. Instructing solicitor, please zoom in at the communities. Yes, at the highlighted green part at the 3rd line. Can you see that the Orang Hulu communities have only taken up permanent residence and begun cultivating food crops?
The Orang Hulu.
Do you agree with me on that statement?
I'm not sure.
Oh, you are not sure, but you have placed this document in part A. Is that
Sorry,
correct?
I have poor eyesight, so
It's okay, Mr. Alfred. I will read it in verbatim for you. The Orang Hulu communities have only taken up permanent residence and began cultivating food crops such as vegetables and hill paddy since the mid-1960s. Do you agree with me on that statement? Were you aware of that?
Counsel, I'm just curious here. Isn't that what the report says? So why are you asking whether she agrees or disagrees? Because it's already in the report.
Arif, because previously the first Mr. Alfred had disagreed with me, stating that she's not aware that PW1's community is an indigenous group. However, according to the report and plan prepared by her task force, it was clearly stated that they know that Orang Hulu community are an indigenous group.
Native and indigenous is different, council. We know both from the facts that it's not entirely analogous. But never mind. What I'm saying is, if that's the case, then just put it to our Mr. Alfred here that it's the evidence is consistent or whatever. But the report says what it says. So maybe you can just put it to the witness instead of us. You're not putting it to the witness. You need to put it to them that there's inconsistent evidence here.
Much obliged, Chang Arif. Witness, I further refer you to paragraph 3 of your witness statement. Instructor Solicitor, please enlarge the document. So at paragraph 2, so you have stated that BEB is controlled by the government. Is that correct?
Yes. The government is the.
Thank you, witness. Thank you, Mr. Alfred. So I put it to you that the management and operation of the Tagul Dam is within the state government, which is the 5th defendant's control. Do you agree with me on that?
The government need to ensure
witness,
that all
Mr.
the
Alfred,
standards.
I only need a precise answer, yes or no. Do you agree with me on that?
Sorry, what is your question again?
Mr. Alfred, so I put it to you that the 5th defendant, which is the state government of Sarawak, is in charge of the operation, is in control of the operation and managing of the Tagul Dam. Yes or no?
They ensure all the standards and legals.
They
Mr. control the government, yes. They control by the government.
Thank you, Mr. Alfred. Thank you, Mr. Alfred.
All right.
Okay. Moving on to my next question. So, referring to your witness statement at paragraph 11. So you have stated that the first plaintiff's community was willing to move out of their Long Burong dwelling place, correct?
Pardon.
So in paragraph 11 of your witness statement, so you have stated that the Long Burong community was willing to move out, correct?
Yeah.
Yes. So, okay, my question to you is, so is the first defendant going to stop the construction of the dam in the event the Long Burong community refuse to move?
Yes.
You are going to stop the construction of Tagul Dam.
I'm so sorry. Pardon. I have this coffee yesterday. Arif, can I drink? Can I have a drink?
Yes.
Thank you.
Counsel, what is your question just now?
My question to the first defendant is whether the first defendant, BEB, would stop the construction of Tagul Dam in the event if the Long Burong community insisted and refused to move out of Long Burong. Yes or no?
You're asking hypothetical questions or what?
It's not hypothetical question, Yang Arif, because as stated in his witness statement, there were initial reluctance, there were objections, and there were oppositions. So my question is, did the first defendant, BEB, intend to stop construction at all? Yes or no?
The fact that
thing did not have. Sorry, Arif.
I mean, I have to stop you there. This is like my younger brother was saying, it's completely a hypothetical situation. The fact that the construction was completed, they were relocated. So let's move on from that, yeah?
Okay, much obliged, Arif.
Arif, because that thing haven't happened, so I don't know what to answer. Thank you, Arif.
It's okay, Mr. Alfred. Moving on to my next question. So my next question is, so you were aware that this Long Burong community actually preferred an isolated place to be relocated. Is that correct?
Yes, that's why they choose
Thank
the
you, Mr.
Mansa.
Alfred. Thank you, Mr. Alfred. So, with the court's permission, I'd like the instructing solicitor to display map 2, showing the project area after construction. Much apologies, to show map 1 instead, map 1, the one before construction. Yes. Mr. Alfred, so in Amansara, do you agree with me that there's already an Orang Hulu community there, which is represented by a gray spot with a cross?
Gray spot. Yes.
Yes. So So I put it to you that the first plaintiff's community has clearly reflected to you they wanted an isolated environment, yet you have failed to provide a resettlement site which is in correspondence with their requirements. Do you agree with me?
Council, can you like simplify your question? Because I am 60 years old, I don't
Certainly.
really get it,
Certainly. Okay, aside from that question, so Mr. Alfred, do you agree with me that in
What is the question again just now? Can you simplify the question before?
Yeah, no problem. Before I move on to that question, there's an additional question that I would like to ask you. So in this map, do you agree with me that like below Sungai Ara, and also beside Sungai Malora, at the right side of Sungai Malora, and then also at the downstream of Sungai Burong, there are a lot of vacant land. Yes.
Can
or
you
no?
show like in the
Certainly.
map?
Certainly. Instructing solicitor, please move your cursor to the vacant land that I'm referring to. Yes. So there
Beside
is
to
vacant.
Sungai Ara, what again?
Below Sungai Ara.
Below Sungai Ara, where is Sungai Ara? This one below, yes, okay.
Yes, and then beside Sungai Burong at the downstream, on the
Sungai
left side.
Burong.
Yes, this part. Can you see that?
Oh, all right.
And at the right side of Sungai Malora. Yes, can you see that? Right side. Correct. So do you agree with me that there are vacant land in these three areas?
Yes, it's shown in the map that.
Yes, thank you, Mr. Alfred. So I put it to you that there are a lot of vacant lands near the vicinity of Sungai Burong, yet you have failed to provide an isolated place which the first plaintiff's community wanted. Do you agree with me on that?
No, you know what? Because we
okay.
give them
Thank
the
you,
map
Mr.
and
Alfred.
also we let them
Mr.
to
Alfred,
choose that.
Mr. Alfred, I only
Let
need
me
your-
explain first.
It's okay. You can
The
explain.
witness, Mr. Alfred, your
Yeah.
lawyer will re-examine on this point.
Oh, thank you.
Then you may be able to explain your position later.
Oh, thank you, Ya Arif. Thank you, Arif.
Mr. Alfred, moving on to my next question. So referring you to paragraph 12 of your witness statement.
Paragraph 12.
Yes, paragraph 12 of your witness statement. It's being shown on the screen now. So referring you to the third line of your witness statement, you have stated that the first defendant has provided the 12 hectares of land per household for crop cultivation. Correct? Yes or no?
Yes, it's shown. I said it just now with my
Alfred, I don't need your explanation. I only need a very short answer, yes or no. So furthermore, I also refer you to paragraph 11 of your witness statement at the last paragraph. So it is also stated here that Amansara was likewise rated equivalent in terms of crop culture potential and resource richness. Is that correct? Yes or no?
Can you repeat your question?
No problem, Ms. Alfred. So at the last sentence of paragraph 11, it is stated that Amansara was likewise rated equivalent in terms of crop culture potential and resource richness.
Oh, the one that you showed just.
So you have stated that it's equivalent in terms of crop culture potential, correct?
Yes.
So I put it to you that you have never explicitly mentioned to the first plaintiff's community that the land is specific for rubber crop cultivation. Yes or no?
Sorry, your question again. I never specifically said.
I put it to you that the first defendant have never mentioned to the first plaintiff's community that the land is specific for rubber crops cultivation.
No, we already mentioned.
Thank you, Mr. Alfred.
Tell them already.
Mr. Alfred. So referring to a paragraph of your witness statement, wherein it states that the land is for rubber cultivation, specifically in paragraph 12.
Your question,
where is it reflected in paragraph 12 of your witness statement?
Oh, it's not all in here. It's in the package resettlement, so you have to refer on the.
Thank you, Mr. Alfred. It's okay. Thank you, Mr. Alfred. So my next question to you is, so in this Tago resettlement action plan, did you or did you not provide any rubber cultivation training to the first plaintiff's community?
Hello?
Hello, Ms. Alfred?
Can you repeat the question?
Yeah, definitely. So in this Tagore
Sorry.
resettlement, in this Tagore resettlement action plan, did the first defendant provide any rubber cultivation training to the first plaintiff's community?
No.
No. You have never provided, okay. You have never provided any rubber cultivation training. So
Because you know there.
I don't need your explanation. It's okay, Ms. Alfred. Okay. Moving on to your to the statement of agreed facts at paragraph 9, subparagraph A, and at paragraph 4, statement of agreed facts. Please show paragraph 4, instructing solicitor. Paragraph 9A4. Yes, much. Thank you, instructing solicitor. So, Mr. Alfred, so as according to what first plaintiffs has testified earlier, so in order for rubber to grow mature, it requires more than 5 years. However, your transition assistance only provides until 3 years. Mr. Alfred, are you with me?
I'm sorry, I'm coughing.
Okay.
Pardon.
Okay. So as testified
Sorry, what is your question?
As testified by the first plaintiff's PW1, Mr. Jahakabis earlier, he stated that rubber needs more than 5 years to grow, but your transition assistance only provides until 3 years. So in the remaining period of 2 years, how can the first plaintiff's community survive without any transition assistance?
Can you simplify your question?
Definitely. So you need, in order for rubber trees to grow mature and for them to tape the latex, it requires more than 5 years. However, the transition assistance provided by you, the first defendant, is only up until 3 years. So how can the...
Yep, so the question is it a cross-examination question, counsel? Because you're asking the witness how, or what kind of, what's the question?
Okay, here comes the plaintiff's question, the cross-examination question. So how can the first plaintiff's community survive at the remaining 2 years with no transition assistance from the first defendant?
You know, they also before they have the land, they also skill, they have also another work, they also catch the fishes. They also have more job opportunities now. So
Mr. Alfred, so you referring to you're saying that, okay, now they have the land, they can plant rubber, but if they invest so since you have only provided 3 years transition assistance, so if they invest all their land in planting rubber, how can they survive at the remaining 2 years?
what do you mean by they cannot survive? I don't understand the question, because they have all the fishes, they can catch the fishes. So while they're waiting for the rubber to plant, they can also get another work. So we give it all. We don't give just one thing for them to survive, They need to plan for their life also.
Mr. Alfred, so I refer you to table 3 on the fish catch. Instructing solicitor, please display table 3. So do you agree with me that Ampura fishes reduced drastically in the year 2019 at Sungai Burong? Yes or no?
Yes.
Okay, thank you, Mr.
You
Alfred.
refer to this table.
Yes.
You refer to this table. So yes, I know.
Yes.
But
Okay. Thank you, Mr. Alfred.
We agree on
Thank you, Mr. Alfred. I don't need your explanation. I
Yes,
need your
please
yes.
do not, witness, please do not engage with the counsel. You're just here to answer questions. Okay.
Okay. So in which year did the Tagul Dam became operational?
You know, I mentioned just now, became operational at 2019.
Okay, thank you.
Completely
Mr. Alfred.
operational 2019.
Thank you, Mr. Albert. Thank you, Mr. Alfred. So moving on to my next question. Instructing solicitor, please display table 2, the National Water Quality Standard. So do you agree with me that Sungai Burong is severely polluted at the year of 2019? Yes or no?
Based on the table, yes.
Thank you, Mr. Alfred. So moving on to my next question. If I refer you to map 1, which is the project area before construction. So in here, do you agree with me that there's no erosion at Sungai Burong? Yes or no?
Which here?
Sungai Burong.
What is your question again?
Is there any erosion in Sungai Burong? Yes or no?
Based on this map?
Yes.
I'm not sure.
Yes or no? It's clearly from the map.
I'm not sure, Yang Arif.
Objection. I believe that my witness have the rights to say I'm not sure.
Moving on to my next question. If we compare both map 1 and map 2 together, instructing solicitor, please scroll, please enlarge the map to show the part where there's erosion. Okay, so if we compare map 1 and map 2, do you agree with me that in map 2, there's erosion at the right side of Sungai Burong? Yes or no?
Can you like?
Perhaps instructing solicitor would like to point the circle where is the
Yes.
area?
If you refer to the map on the right side, the instructing solicitor is pointing the area of erosion with her cursor. So do you agree with me that there's erosion at the right side of Sungai Burong?
Based on the map, yes.
Yes, okay. So this map is dated 2020, correct? Instructing solicitor, please scroll down to show the source and date. So this map is in the year of 2020. Do you agree with me?
That one, the early one is 2010.
I'm referring to the map on the right. The date is 2020, yes or no?
Yes, it's stated in the map.
Yes.
You see?
Yes, so I put it to you that the erosion happens after the construction, due to the construction of Tagul Dam. Yes or no?
No, obviously
Thank you,
no.
witness. Thank you, witness. Thank you, witness. So referring to paragraph 15 of your witness statement, so you have forecasted heavy rainfall in December 2020 and into January 2021, correct?
Yes.
Yes. So since you have forecasted this heavy rainfall, I further refer you to document 3, the SEIA report at the proposed mitigation measures. Yes, please enlarge the, yes. So here, at paragraph B, it states that the defendant should also construct silt traps and desilt the silt traps at least once a week and after heavy downpour.
Paragraph B.
Yes.
Oh, okay.
Yes, it's highlighted now. Can you see that?
My computer doesn't show highlighted, but I see the cursor.
Yes. So it's
okay. It's highlighted now.
Okay. So my question to you is, as testified by the second plaintiff's community, PW2, Salib Ana Rumin earlier, she only see He has
All
only
the
seen
participants, please observe the time limit, please.
much obliged, Yang Arif. He has only observed the first defendant desilting the silt traps once a month. So I put it to you that you are not the first defendant is not complying with this SEIA report. Yes or no?
Tulo, what is your question again?
Mr. Alfred, so here it states that the silt traps must be desilted at least once a week. As testified by PW2 earlier, the first defendant has only desilted the silt traps once a month. I put it to you that the first defendant has failed to comply with this SEIA report. Yes or no?
No.
Thank you.
No.
Thank you, Mr. Alfred. Yang Arif, this ends my cross-examination for DW1, Mr. Alfred Sherlock.
All right.
Thank you.
Thank you, defendants' counsels. Plaintiff. Thank you, plaintiff's counsel. Defendant's counsel, you may now re-examine your witness.
May it please the Honorable Court, I will now start my re-examination. Mr. Alfred, are you ready?
Yes, I am very ready. Are you okay?
Yes, thank you for asking. Okay, Mr. Alfred, just now that you agree that 3 communities are indigenous people, can you explain that why do you disagree that they are native?
No, I agree. They are indigenous people, but they are not native.
Why do you agree that they are indigenous but not native?
Because they live there already, and they are undisputedly indigenous people.
Okay, thank you, Mr. Alfred. Just now you mentioned that the 5th plaintiff is in control of managing the dam. Can you explain more about this?
The 5th plaintiff is in control of the managing the dam because they have no Can I have a drink first?
Yes, I'm sorry.
So they have access to the modern facilities.
Okay, Mr. Alfred, just now you disagree that you failed to resettle them in a vacant land. Could you explain why do you disagree?
Because the vacant land not owned by the government, but privately owned. So the quality life of the plaintiff would also decrease if we move the plaintiff to the area.
Okay. Mr. Alfred, the plaintiff's counsel argued that I'm sorry, I'm gonna rephrase my questions. Why do you say that the first plaintiff can survive the remaining 2 years while waiting for the rubber plant to cultivate?
Because meanwhile waiting for the rubber tree to give their benefits, they can also have many job opportunities because got school, got clinic, got market. So the BEB also give them sufficient reskill program, so they can use the skill where they got from the program. So on that also, if the first plaintiff use all the subsidies and monies that given by the BEB for the rubber tree, we all know that it will took more than 3 years what plaintiff said in the contract, and also they all agree with the package. So yeah.
Oh, much apologies. Just now you agree that the water is polluted in Sungai Burong based on the table. Can you explain more about that?
Because you can see the table that the water is polluted, and it must be noted that it does not polluted by the dam only. So we cannot merely say that the river is polluted by the dam. It can also by other factors. There are also other things on the river. The river is so long, you know.
Okay. Thank you, Mr. Alfred. Moving on to my last questions for this re-examination. Just now you agree that there is erosion based on the map on the right side of Sungai Burung, and you disagree that erosion happened due to the construction of Tagul Dam. Can you explain why you said so?
As I mentioned just now, that we cannot simply mention that all the things happen because of the dam, because you know there are other things. Erosion are so natural occurrence, so it's too remote for us to say that the dam is the sole cause of the erosion.
Okay. Thank you so much, Mr. Alfred. With that, I end my re-examination.
All right, thank you, Mr. Alfred. You hereby discharged from testimony.
Thank you, Yang Arif.
Yeah. Have a safe flight to Sarawak. All right, Defendants Counsel, you may have you may call your next witness now. This is your last witness, right? Which one? Which one is handling this witness? Who's handling this witness? Siti.
Nisa, I believe my counsel is Nisa Batrisha.
It's frozen.
Yeah. The
think
line is not stable. DC2, frozen.
Pardon, Yang Arif. May the court give us a few moments just for the second defendant counsel to get ready?
Sure.
Thank you, much obliged.
While we on that, what is the role of the second witness?
I am the environmental protection officer, and also my expertise includes the review and facilitation of environmental impact assessment. And other than that, I also have been part of the development of the Tagul Resettlement Action Plan by helping them overseeing the option for resettlement area.
So my question to counsel. So this is your expert witness or what? Who are the counsels for the defendant?
Yes, I believe that this is our expert witness.
All right, okay. So expert witness should be precise and concise, huh?
I'm sorry, Yang Arif. Our second defendant counsel is trying to get her line and try to re-enter this meeting.
Sure.
I'm so sorry for the inconveniences.
Okay, we are towards the end of our proceedings. Perhaps parties can, both parties, plaintiffs and defendants, can prepare their closing arguments. Right? I know that you guys had prepared, had tendered and submitted closing skeleton submission, right? Before you have, right? But along the
we have.
Yeah, so but we can see from today's proceedings what are the directions, what are the points stressed. So please try to chip in or blend in what are the points raised today in your skeleton submission as well. Okay. Patricia still offline?
Yes, because the link that is provided, it is somehow buffering and she can't enter into the meeting.
All right. Have you contacted the committee?
I will do, Yang Arif.
Wafi Anwar is committee or what? Wafi Anwar.
Yes, I believe that Wafi Anwar is the committee.
So committee, could you lend your assistance? Thank you.
My apologies, Yang Arif, for the delay. My laptop had a problem just now. My apologies. All right, so now if I may proceed with the next witness.
Yes, please.
All right. All right, Yang Arif, my name is Nurnisa Batrisha binti Muhammad, the second counsel on behalf of the first defendant. May it please the court, may I call upon the second witness for the defendant, which is Ms. Juliana Abil. All right, Ms. Juliana, please read the oath before the court.
I swear the statement that I am about to give is the truth, the whole truth, and nothing but the truth.
Ms. Juliana, will you be answering the questions in English or do you need a translator?
I can speak in English, so English it is.
All right, so Yang Arif, since we have submitted the witness statement to the court beforehand, do we need to go through the witness statement once again?
Yes, because
right,
that's how
sure,
we judges evaluate your performance. Okay.
All right, Yang Arif, I humbly pray for the Honorable Court to question the witness. So, Ms. Juliana, do you have a witness statement today?
Yes.
Yang Arif, pardon me, Ms. Juliana, so can you please state your full name, age, and occupation?
My name is Juliana Abil. I am 48 years old. I work as the Environmental Protection Officer at the Sarawak Environmental Protection Agency, or known as SEPA, for 25 years. I am a generalist in the field of environmental science, and my expertise include the review and facilitation of environmental impact assessment.
So why are you here in the court today?
Well, I was asked to give my statement pertaining to this case today, as I was directly involved in the Tagul Dam project back in 2011 until 2015. I had also been part of the development of the Tagul Resettlement Action Plan and responsible for overseeing the options for resettlement sites for the Orang Hulu community that is affected.
So who are these Orang Hulu communities that you mentioned just now?
So these are the Orang Hulu community who had been directly impacted by the Tagul Dam construction, which are the Long Borong, Long Tara, and Long Tagul. These communities are largely engaged in cultivating hill paddy and growing tapioca and other vegetables.
So does the resettlement site carry the same value with their previous land?
Yes, it was deemed to be comparable in terms of its value and thus a suitable resettlement site, coupled with the measures identified in the resettlement package and the greater access to the public amenities. Long Borong would be in a significantly improved position.
So would you be able to explain what is the procedure for the resettlement?
Yes, sure. So for the first step for resettlement is the consultation. So for this, over 30 formal consultations and another 20 informal consultations had been carried out with the Long Borong, Long Tara, and Long Tagul communities between 2011 and 2015 in conjunction with the SEIA. After that, two potential resettlement sites, which are Melora and Amansara, were suggested by the BEB. Next, Long Tara and Long Tagul will be choosing their preferred site. And after the decision has been made by them, resettlement of the Orang Hulu communities will take place.
So how do BEB ensure that the SEIA process is properly conducted?
The SEIA process was carried out according to the international standards for resettlement. These include the World Bank operational policies, the International Finance Corporation Performance Standard, and the United Nations Declaration for Rights of Indigenous People. Other than that, BEB also follows the Millennium Development Goals framework for the state and federal programs and policies for poverty eradication.
All right. So, Yang Arif, I pray to the court to refer the witness to document 3. If the instructed solicitor may share the screen for the document 3.
I am now showing the document. Is it visible to the court?
No, no instructing solicitor.
No, okay. Is it now visible?
Yes, indeed, instructing solicitor, much obliged. So, Ms. Juliana, can you identify this document?
Yes, this is the latest assessment done for SEIA.
All right, so would you be able to explain to us regarding the latest assessment done for SEIA?
Yes, sure. The assessment were done and updated as of 2015. Whilst it is true that recent 2020 reports indicate a drop in fish biodiversity in Sungai Burong, and there is also a decline in water quality, but these alone are not sufficient information to attribute that the decline to the dam-related activities. Between 2015 and even until now, development around Sungai Burong downstream from the dam has also intensified. And this include logging, road construction at a future hill resort.
Yang Arif, I pray to the court to tender and mark the latest assessment of SEIA as an exhibit.
Yes, proceed.
Right, Yang Arif, by me, what is the name of the exhibit? Sorry, Yang Arif. Yang Arif? Pardon me, but may I know if the court marked the exhibit as what exhibit?
The last one is P8, right? Is it
Yeah.
P8? So it should be either D1 or D9.
Yeah.
All right. Much obliged, Yang Arif.
Can be D9.
Can be D9, yeah?
All right, yeah, much obliged. Next, I pray for the court to share a document with the defense witness, which is an exhibit tendered by my learned friend just now, which is exhibit P7. So, Ms. Juliana, can you identify what document is this?
Yes, this is the data of the fish catch from 2011 until 2020 at Sungai Burong and Sungai Ara.
All right, so I pray, pardon me. Can you explain, Ms. Juliana, regarding this data?
So from this data, we can see that there was a decline in the majority of the species due to the change in habitat characteristics from river to lake. So there will be a loss of the river specialist species. Some fish may migrate to other parts of the rivers, but if the other parts of the river are also subjected to the pollution due to the other human activities, the fish stock will also further decline as their breeding grounds will be destroyed.
All right, moving on to the next question. So is there any follow-up made on the Tagul Dam project?
Yes, a recent investigation was made into the cause of the massive floods in December 2020 and also January 2021 that caused us to revisit the SEIA for the Tagul Dam construction.
So based on the investigation, what are the causes of the massive floods?
Well, it is due to the increasing rainfall experienced in Melora and the Penyalang areas the past years, coupled with the new construction and erosion. The Sungai Burong Baru is subjected to the heavy sedimentation. So these are no doubts would contribute to the cause of the bad flooding experience in Amansara.
So what is done after the flood incident?
The Natural Sources and Environmental Board Sarawak is actively monitoring environmental issues, and we hope to soon engage with the communities downstream from the Tagul Dam to identify further interventions.
So is there anything else you would like to add, Ms. Juliana?
Well, in this case, I do believe that BEB has conducted the project honestly for the benefit of people in Sarawak. Indeed, these natural disasters are inevitable as the water level is rising and unavoidable due to the global warming that is happening to the world. It would be unfair to put the blame on BEB as we cannot predict a natural disaster.
Right. Before I tender the witness statement, Ms. Liana, is there any amendments that you want to make on the witness statement?
I did not have any amendment.
All right. So could you please sign, Ms. Liana, the witness statement and dated the date of on 5th February, the today's date?
Sure.
Right, much obliged, Ms. Juliana. So now I pray for the witness statement to be taken and marked as exhibit, Yang Arif.
Right.
Much obliged, Yang Arif. With that, there's no further examination in chief by the defense counsel. Much obliged.
All right. Plaintiff counsel number 2, you may proceed with the cross-examination.
Much obliged, Yang Arif. Ms. Juliana, I'll be asking you a few questions based on the examination in chief that was conducted by your counsel. Please answer my questions to the best of your knowledge. Ms. Juliana, as I understand, you are the expert who conducted the environmental impact assessment, right?
I did not conduct the environmental impact assessment. I am in charge to review the SEIA report made by the Awesome Social Environmental Assessment Berhad.
And you are working for the first defendant, right?
I am working on behalf of the government.
You're working on behalf of the government. And what is your relationship with the first defendant then? Because as I was made to understand, you're part of TRAP, right?
Yes, I also work with them, collaborate with them in giving my advice on which resettlement site is deems to be comparable to the Orang Pulu communities there.
Ms. Juliana, the first defendant and yourself have recommended Kampung Melora and Amansara, specifically Long Burung, as the two options available to the first plaintiff, right?
Yes.
Are you aware of the conditions, or rather the specifications that were given by the first plaintiff with regards to the relocation?
Yes, they do give certain specification on what they want from the resettlement area. So
Thank you. In addressing that, would you agree with me that those two conditions are firstly, the fact that the site must be isolated, and secondly, they want to be closer to their burial grounds in Long Burung? Would you agree with me that those are the two conditions?
It is among of the condition provided by them.
What do you mean more of the condition?
Among of the condition provided by them. Among of the condition.
Yang Arif, we request the instructing solicitor to display map 1 and map 2 side by side. Ms. Juliana, on the left side map, can you see the red colored cross, which is designated as Long Burung? Instructing solicitor, can you move your cursor to the red color spot?
Okay, I can see it. I can see it.
Yes, and now on the right color side, the light blue circle with a cross. Light blue. Okay. Not the other one. The other one.
The other one. All right,
Yes.
right, okay.
And this is the location that you have relocated the first plaintiff to. Based on what you stated earlier, the first plaintiff specifically stated that they want to be closer to their burial ground, which is the red color spot. And secondly, they want to be closer to, they want to be isolated away from other communities. Would you agree with me that this doesn't comply with their conditions, to their specifications?
No.
You don't agree with me? Fine. Instructing solicitor, you can close up, never mind, it's okay. Since you gave the review of the SEIA report, would you be able to assist the court with regards to the studies that you have performed on the environment in Amansara as well as Sungai Burung?
You want me to explain on that?
Yes, yes.
Okay. In Amasara
No, I haven't
and
asked any questions yet. I'm just asking whether you're able to assist the court on the environmental impacts on it.
oh yes.
Okay. Ms. Juliana, can you see on the left-hand side map? Can you see all the Nkabang trees that are planted along Sungai Burong?
Nkabang trees?
Yes.
The XX1, the small
Yes.
X1? Oh
That's
yes,
right.
I can see. I can
And
see.
would you agree with me that on the current map, the latest map, which is the right-hand side map, the Nkabang trees have been cut down? Would you agree with me on that?
Yes, I can see
Would
it.
you agree with me that the defendants cut down the Nkabang trees?
No.
You don't agree with me on that. Can you see the access road on the right-hand side map? Instructing solicitor, perhaps you can move your cursor along the access roads on the right-hand side of Sungai Burong. The right-hand side of Sungai Burong. That's right. Can you see the access roads?
Access road.
Yeah.
Okay. There's access road there.
All right.
I can see it.
Would you agree with me that the defendant cut down the Nkabang trees in order to make way for the access roads?
No.
Yang Arif, we request the instructing solicitor to display document 3, which is the social economic impact assessment that was previously tendered to the court by the defendants as Exhibit D9. Instructing solicitor, can you please highlight on the first paragraph or paragraph A, that these impacts are not merely from the construction and impoundment of the Tagul Dam, but also all associated developments, which would include construction of a power station, construction of the roads to access the project sites, construction of the campsite, etc. This shows that the defendants are the ones who constructed the roads as well as cutting down the Nkabang trees. Would you agree with me on that?
No, I didn't agree.
Okay. Instructing solicitor, please revert back to the previous 2 maps that you showed. Can you put the old map on the side, on the left-hand side? And the new one on the right-hand side, please. Okay. Ms. Juliana, would you agree with me that instructing solicitor, for the sake of clarity, let's keep it consistent. The old one should be kept at the left side. Please move the new one to the right-hand side. Okay. Ms. Juliana, would you agree with me that on the right-hand side map, there are embankments built?
Embankment.
You can see that clearly, right? The embankments.
Can you
the instructing solicitor showing on the map.
Oh, okay, the embankment, yes.
And the areas that are not covered by the embankments, which is right below the embankments, that are all affected by erosion. Can you see that clearly?
From the map itself, you want to see like that the below the embankment is affected by erosion, right?
Yes.
Okay. Yes. From the map, yes.
Okay. So based on everything that you've answered just now, I put to you, Ms. Juliana, due to the deforestation of the Nkabang trees and also the construction of the access road by the defendants, it has caused the erosion. Would you agree with me on that?
No, I didn't agree with that.
Instructing solicitor, please display the document 3, which I just referred to earlier just now. Please go to the proposed mitigation measures. Apologies. You can go to the construction above that, please. Can you scroll down a little? Above, scroll up a little more. Yes, a bit more to item number 2. Okay. Here, it is specifically provided the construction of the dam and other infrastructure could result in erosion and siltation. Can you see that clearly?
Yes, I can see it clearly.
You agree with me? You earlier agreed with me that this is the exact report that you reviewed and approved, right? on behalf of the government?
Yes.
Okay. Instructing solicitor, please scroll down to the proposed mitigation measures. Can you please highlight item B, paragraph B? Earlier, the plaintiff's witnesses have testified before the court that they have only observed the defendants performing desiltation on a monthly basis. This specific mitigation measure that you have approved and reviewed states that the desiltation should be done on a weekly basis and after heavy downpour. Could you perhaps clarify to the court the position of the defendants?
Well, from the proposed mitigation measures, they stated that the desiltation trap should be conducted once a week and after a heavy downpour, and that is hence why I agree with the SEIA report made by them.
But Ms. Juliana, I'm afraid you're not answering the question. The witnesses have earlier testified that you only perform the desiltation on a monthly basis, but here your own proposed mitigation measure specifically provides that you're supposed to do it on a weekly basis and after heavy downpour. So this means you have not complied with your own provisions in the SEIA report. Would you agree with me on that?
It is not on my part whether they comply or not, because it is upon the BEB itself whether they wanted to follow the SEIA. However, upon the revisitation that I made, I discovered this thing after the revisitation that I made after the flood. But even though they did not follow the desiltation plan stated in the SEIA, but I found that this not cause a significant impact on the erosion itself, because the desiltation that they made once a month, it is according to the change in the dam itself. So that's why they did not follow the SEIA report.
Yes, Ms. Juliana, I would like to quote what you said just now. The effects on the river were caused by the dam itself. That's what you said just now, right? That was your last sentence. Yes.
The dam, I think I didn't say like the dam itself.
No, I was quoting ad verbatim, literally what you said just now in the last sentence. I would like to just clarify, is that what you said?
Can you state it back what I said? What
yes, you in the last sentence just now, and to quote verbatim, you said the effects on the river were caused by what happened in the dam itself. That's what you said, right?
Oh, I see that the change of the mitigation factors, it is due to the change in the dam itself. So that is why they make a change in the mitigation measures.
So if there is a change in the dam itself, and then why then is the quality of the water still deteriorating, as we have seen from the tables and also the testimonies from the witness? Could you explain on that?
Well, it can cause by a lot of reasons there, because the dam construction is not the only construction there. There is also a hill resort that took place there. There is also poachers from unknown third party there. So I think it would be unfair if you only say that the quality water decreased due to the dam construction itself. Okay. And also,
Ms. Juliana, you are shifting the blame to other parties, but I would like to point out to you paragraph A and paragraph C. Instructing solicitor, would you kindly please highlight paragraph A and paragraph C here, so that we're all clear. Now, paragraph A, Ms. Juliana, this is the report that you approved, states that to avoid erosion and desiltation, a buffer of vegetation should be built. Now, instructing solicitor, in relation to paragraph A, please display map 1 and map 2 side by side. Now, Ms. Juliana, earlier during the previous questions, you've already told us that Engkabang trees were cut down, and you have also identified in the CIA report, it states that you're supposed to plant vegetation as a buffer. Now, on the map, you have not planted any vegetations as a buffer. And I put to you that since you have not planted as vegetations as a buffer, That is the reason why there is a significant erosion on the right side of Sungai Buloh. Would you agree with me?
No, first of all, I didn't say that we need to cut the Engkabang trees.
But Ms. Juliana, as I've already pointed out in the SCIA report, it specifically provides, Young Arif, before I proceed, instructing solicitor, please display SCIA report, paragraph A, environment. Now, here it is specifically provided that in order to facilitate the construction of the Tagul Dam and all associated development, which is the power station, the construction of the access roads, a significant portion of the environment would have to be deforested. Now, this means that since you didn't plant the buffer vegetation, that is the reason why there's a significant erosion. Would you agree with me?
No.
Okay. Instructing solicitor, please display the maps again. Thank you. Earlier, you agreed with me that there has been a change in the desiltation process, right? You stated that the defendants switched from weekly and after heavy downpour, they moved on to the protocol of every month, right?
Yes.
Okay. Now, would you agree with me that when desiltation is not done on a regular basis, it would cause sedimentation of the river and subsequently make the rivers shallower?
Once again, okay?
Yes. Would you agree with me that when desiltation is not carried out on a regular basis, it would exacerbate erosion and further cause sedimentation of the river? Would you agree with me on that?
No.
You don't agree with me on that. Okay, would you agree with me that if there is a severe sedimentation of the river, it causes the river to become shallower?
Again?
Would you agree with me that if there is severe sedimentation of the river, it would subsequently cause the river to become shallower and shallower?
Yes.
You agree with me on that? Just to clarify the position of the defendants, you have answered that erosion would not cause sedimentation, but however, you're saying that the sedimentation will cause the river to become shallower. That is your position, right?
Actually, I said that erosion, to put it solely on the defendant for the cause of erosion is not fair, I think, because I said that the erosion that may be caused by the defendant does not have a huge impact, a significant impact on that, on the Orang Kelu communities. Because
Ms. Juliana, allow me to ask the question. In regards to this, you're saying that the logging concession camp and the hill resort is the one that caused the erosion and the sedimentation. However, would you agree with me that on this map, a significant portion of the development on Sungai Burong itself and right next to the Sungai Burong is actually done by the defendant? Of course, I'm referring to the Tagul Dam as well as deforestation of the Engkabang trees as well as the access roads. Do you agree with me on that?
It may caused by other people also.
You're saying that it's maybe caused by the other people. So I put to you, Ms. Juliana, compared to the hill resort, the Tagul Dam and the access roads are nearer to Sungai Burong, right?
Tagul Dam, can you
I'm referring to the right side map. The Tagul Dam is literally on the river. It's built on the river, right?
Yes, on the river, yes.
And the access road is right next to the river where the erosion happens, right?
Yes.
But the hill resort is situated further away from Sungai Burong, right?
If you ask me, I did not think that there is too far away from the access road.
But based on the map, you can see that the access road is right next to Sungai Burong, but the hill resort is on top of a mountain, right? It's a mountainous area. Would you agree with me on that?
Yes.
Okay, now let's go back to the argument that it's caused by other developments. We have addressed hill resort. With regards to the logging concession camp, would you agree with me that neither the first logging concession area nor the second logging concession area are nowhere near Sungai Burong? They are all both inland, right?
No.
Okay. Yang Arif, that concludes the cross-examination of the second defense's witness. Much obliged, Yang Arif.
Thank you.
All right. Much obliged, my learned counsel. So now I'll be moving on with my re-examination. So, may please the court. Ms. Lena, Just now you disagree that you did not satisfy with the requirements imposed by the first plaintiff. So can you explain why?
The requirement for the resettlement.
Yes, for resettlement of the first plaintiff.
Okay. So firstly, when we did a consultation with them, we even did the consultation way before the dam construction had took place. So during that time, we also already explained to them like, okay, so these places are going to construct a dam. And we also proposed to them that due to the dam construction, they need to move to another place. And then, but due to the certain standard stated in the international standard, so we need to follow the standard. So we asked them what are their demand, what are their usual daily what they did there, basically what they did there lah. And then due to response from them, we can conclude that they want to be replaced in a site that is closer to their burial, their ancestor burial, and then because they are live in the forest for many years, so they wanted to move into a secluded area compared to the Melora, so that is why they choose the Amansara. So we did try to comply with their needs, where we also identify that they are fishermen, the crops that they plant, and we try our best to comply with their demands.
All right, I see. Thank you. So now moving on to the next question. Just now you disagree that the defendant did not cut down the Enkabang tree to make the road. So can you explain why, Ms. Juliana?
Yes, I do think that there is a huge allegation made against the defendant because it can cause by other factors also, because the river is very long. It also contains a construction project that is illegal. So I cannot trace all of them. So to say that the erosion happened due to the defendant's action is quite is a huge allegation too, because the BEB, the first defendant, has also tried their best to comply with the standard that they upheld.
And then, Ms. Juliana, why did you say that the areas after the embankment was not built is affected? Can you explain further?
Because
affected by flood.
Because the embankment that we made is for the safety of the community, of the Orang Hulu community as well there. And then when the flood happened, it is beyond our control too, because we did not expect that in the year of 2020 and 2021 it can cause a huge flood. And also during that time, it is the first year in the decades that the rainfall is huge there.
I understand. I see. So now, just now you mentioned that you disagree that the erosion was caused by the construction and deforestation of the defendant. Could you explain why?
Yes, I do disagree with that, because deforestation that was done by third party is not within our knowledge, and it is out of BEB's control. And as the Plaintiffs' Counsel also asked me earlier regarding the position of the resort hill, even though it's situated on the hill, but I believe that to make access, to make a road on the hill, also need to make a access way along the river as well to make the construction. So I believe that it is not only on the hill, also affected the road there, the road. along the Sungai Burong.
I see. Thank you, Ms. Jana. So last question. Why did you mention that the sedimentation will cause the water of the river to be shallow? Can you explain further?
Yes, it is shallow due to the, as I said earlier, it can cause by the logging activities, it can cause by logging activities that was done by unknown party, and will cause the sediment, and the sedimentation will be stuck at the bottom of the river, causing the water level to be more shallow. And also the logging activities does not only took place like for 1 month, 2 months, it took place for many years. So to put the blame on BEB only, I think it is not fair.
Indeed. Thank you very much, Ms. Jana, for answering my question. Yang Arif, that is all for my re-examination for my witness. With that, I pray to the court to humbly release my witness if there's no further clarifications from the court.
Yes, thank you.
Much obliged, Yang Arif. There's no further witness that we would like to question in this proceeding.
So
Yang Arif.
the defendants close their case.
Yes, Yang Arif.
All right. Okay, we will now proceed with the closing arguments. Do you require 2 to 3 minutes to regroup and?
Yeah, Arif, I'm prepared to give my closing submission right away. I do not require an extension.
Right. So in this proceeding, who will submit first? Plaintiff?
That will be the plaintiffs. I will be submitting on behalf of the plaintiffs.
All right. Okay, please.
Request the court permission for the instructing solicitor to display the skeletal closing submission for the plaintiffs. Yang Arif, my name is Jaya Ganesh, and I appear before this court representing the plaintiffs. Yang Arif, in order to set the record straight before I proceed on to my closing submission, it is the position of the plaintiffs that the authority, or rather the authenticity of the documents and the evidences adduced before the court could not be challenged. That is the reason for that is because it is specifically provided in the rules that the authorities and the evidences that are adduced in the form of tables and the documents are deemed to have been sourced from credible sources. In addition to that, the sources have also been specifically provided under the maps and the tables, and as such, the defendants should not be allowed to question the authenticity of the data. Yeah, Arif, I will be addressing 15 issues in total. Some of the issues I will be addressing simultaneously as they are related. To begin with, Yang Arif, the issue of whether the first and the second plaintiff's communities are natives, and in relation to that, issue 2, whether the first plaintiff have native customary rights over their land in Long Burong. Yang Arif, it is the position of the plaintiffs that the PW1 and PW2, Mr. Jaha and Mr. Salib, are both natives and indigenous people that are recognized under the Sarawak government, and as such, they are entitled to protection under the Sarawak government. And in support of this, Yang Arif, we're referring to the clarification, which can be seen at page 7, paragraph 1. Instructing solicitor, please display to the court, where it is provided that the community members from Long Burong, Long Tara, and Long Tagu, as well as Long Keri, are deemed to constitute as one of the native communities that are recognized under the applicable law. The first plaintiff is from Long Burong, and the second plaintiff is from Long Keri. Yang Arif, in addition to that, we'd also like to refer the court to Article 161A of the Federal Constitution, which provides that the term natives and the term indigenous people are analogous to each other. And if I may quote directly from Article 61A, the Federal Constitution uses the term native to refer to the heterogeneous indigenous people of Sabah and Sarawak. The instructing solicitor, please revert back to, thank you. As such, Yang Arif, there should be no dispute as to the position of the first and the second plaintiff as natives that are entitled to the protection under the laws of Sarawak. In addition to that, Yang Arif, in addressing the second issue, it is the plaintiff's submission that the first plaintiff is entitled to the protection of native customary rights that is enshrined under Section 5, subsection 2 of the Sarawak Land Code 1958. Instructing solicitor, please display. Now here, it is provided that the methods by which native customary rights may be acquired are the following measures: the use of the burial grounds of shrines, occupation and the cultivation of lands, planting the land with fruit trees, as well as felling of the virgin jungle. Now we have heard from the first plaintiff, Mr. Jaha, and he has stated that as of 1955, his community has been felling jungles, has been using it for their occupation, and have also been using the land in Longborough for their burial grounds. They've only permanently resettled there in 1965. Instructing solicitor, please display the closing submission again.
There is a provision, right?
Apologies, Yang Arif, can you please repeat?
Provided that, hold on.
Please go back to the provision. Yes.
So provided that.
Provided that until a document of title has been issued, in respect thereof, no rent has been charged by the government.
There is provision there.
Yes,
right.
Yang Arif. However, since within the confines of this moot trial, we are not allowed to adduce any evidence.
Okay. Thank you very much.
As such, we're not able to provide the document of title.
All right. Thank you.
Much obliged, Yang Arif. Instructing solicitor, please display. Yang Arif, our claim on native customary rights is not limited purely on the laws of the Sarawak Land Code. In fact, we are relying also on common law position on native customary rights. And we would like to illustrate to the court, based on the decision of the Australian case of Northern Territory of Australia and Mr. A. Griffiths. Now, this is held at the Apex Court in Australia, which is the High Court of Australia, where the court stated that native customary rights must also be recognized in relation to the cultural activities, which is the practices of birth and death, as well as the burial rights that are practiced by the indigenous people. Now, we have heard from the first plaintiff, Mr. Jaha, that they have been practicing their tradition and their culture in Longborough since 1955. They have been using that place as their burial grounds. As such, Yang Arif, the first plaintiff has acquired native customary rights over Longborough as a matter of the provisions under Section 5.2 of the Sarawak Land Code. In addition to that, also under the common law position enshrined under the case of Northern Territory of Australia. Next, Yang Arif, on issue 3, whether the first plaintiff's community's right to property under Article 13 is violated since no adequate compensation was given, and subsequently whether the plaintiffs are entitled to compensation for the violation of Article 5, Clause 1, and Article 8 of the Federal Constitution. We submit that the plaintiff's rights, both the plaintiff's rights under Article 5, Clause 1, is infringed because their livelihood has been taken away from them, Yang Arif. Yang Arif, when the first plaintiff moved from Longborough to Longborough Baru, they were given hopes that they would be facing a better future for themselves and for their children. They were promised access to education, healthcare, and a brighter tomorrow. They were also promised employment opportunities. And finally, Yang Arif, they were also promised that they would never have to starve ever again. And they also promised that their children will be given better access to education so that we could improve their literacy rate in their community. Yang Arif, all of this entails the livelihood that is enshrined under Article 5, Clause 1. And when the defendant has made all of these representations and they have failed to meet the expectations that they have given to the first plaintiff, we submit that the first plaintiff's rights, as well as the second plaintiff's rights under Article 5, Clause 1, has been infringed. They are now forced into a position where they are forced to rely on the subsidies given by the first defendant. With regards to the second defendant, he's now forced to compete with the first plaintiff's community with regards to his fish catch. His fish catch is barely enough for his own community, Yang Arif. With regards to equal protection that is enshrined under Article 8, Clause 1, we submit that this has been violated because, as previously submitted, the first plaintiff has native customary rights over his land, and his position as a native is recognized under Sarawakian law. As such, since his position is not been protected, this is a violation of Article 8, Clause 1, since he's not been given equal representation and protection under the law of Sarawak. Next, Yang Arif, with regards to compensation, we're referring to Article 8, Article 13, Clause 2 of the Federal Constitution, which instructing solicitor, please display Article 13, Clause 2. Thank you. Article 13, Clause 2 states that no law shall provide for the compulsory acquisition or use of property without adequate compensation. Yang Arif, regardless of how the defendants paint the picture in the present dispute, it doesn't take away from the fact that the plaintiffs are entitled to adequate compensation, because this is a fundamental right and given under Article 13, Clause 2. We submit that this right under Article 13, Clause 1, where they cannot be deprived of the property, has been violated. Instructing solicitor, please revert back to the closing statement. Thank you. Now, the reason why this has been violated with regards to the first plaintiff is because his land has been taken away from him forcefully. The defendants may argue that they have given a choice with regards to relocation. However, this choice was essentially made with false promises and misrepresentations that were given to the first plaintiff, who promised many things, as I have previously illustrated, and those promises were not kept by the first defendant. Subsequently, with regards to the second plaintiff, Yang Arif, his land in Amansara, where he barely has enough resources to rely on for himself, he's now facing a position where he has to compete with the first plaintiff. We agreed that the defendant has not reneged on the property of the second plaintiff. However, it is our submission that there has been no adequate compensation that was made to the first plaintiff. And in support of the definition of adequate compensation, we're referring to the case of Adong bin Kuwau, where the court stated that compensation must be adequate. And this is in reference to the Australian case of Mabo. In addition to that, adequate compensation, when the court awards an adequate compensation to the aggrieved party, it must be for the loss of livelihood and also the hunting grounds of the plaintiffs. Now, as I've explained earlier, the first plaintiff was forced to relocate from Long Burong to Long Burong Baru based on the representations. However, the compensations that were given to him were in the form of inadequate subsidies and also promises that his land will be fertile for the planting of cash crops and food crops. However, based on the testimonies that we have seen, the first plaintiff as well as the second plaintiff has testified that the land is indeed not fertile and suitable for growing any form of vegetation. In fact, the vegetation that they have been growing on are minimal in nature, and they're not relying on it entirely. In fact, the first and the second plaintiff, when they moved to Amansara, they're both primarily relying on the fishes in Sungai Burong as a means of subsistence and as a primary source of income. When the first defendant offered subsidies, when the first defendant offered the land and also the longhouses, these did not constitute an adequate compensation within the meaning of Adong bin Kuwau, because it does not replace the loss of the livelihood that is suffered by the first plaintiff when they moved from Long Burong to Long Burong Baru. Their positions and the conditions in life, their livelihood was significantly better in Long Burong compared to Long Burong Baru. Instructing solicitor, please scroll down. In support of this, Yang Arif, we'd like to also point out that when awarding an adequate compensation, instructing solicitor, please scroll down to the last paragraph. Yes, thank you. Here we can see that adequate compensation must not just be adequate, it must also be sufficient and reasonable based on the long-term scale, Yang Arif. Now, the term long-term scale here is of importance because when the first defendant offered subsidies, it was only contemplated for a period of 3 years. And the year now is 2022. And as of today, the first plaintiff will no longer be receiving any form of subsidies. They have suffered due to the flood that is caused by the first defendant. They have suffered because of the inadequate subsidies. They have suffered because they have to compete with other communities with regards to the number of fish catch. They have also suffered because their land is infertile. Yang Arif, the subsidies that are given by the first defendant are not adequate compensation because they do not contemplate a long-term scale. Subsequently, on the next issue, whether the approval of the SCIA report was prepared by the first defendant in mala fide and the project was obtained illegally should be null and void. Yang Arif, the SCIA and the TRAP report was completed in the year 2016. However, the commencement of the Tagul Dam project began in the year 2013. Yang Arif, this shows that the approval process was only done after the commencement actually began. Yang Arif, we submit that this is a blatant abuse of power and process. And in support of this, we'd like to refer the court to Section 3, subsection 1, paragraph A of the Natural Resources Environment Ordinance. We're saying that there is an abuse of process and power because the third defendant named in this present dispute is the minister, and he's acting as the chairman for the Natural Resources and Environment Board. Instructing solicitor, please go to the next authority. Yang Arif, this is the Natural Resources and Environment Board's notification, which specifically provides the third defendant is the one that is responsible for approving any report submitted to the board with regards to environmental impact assessment reports. The third defendant has abused his position of power and has also abused the process by approving the Tagul Dam project and also these SCIA and trap reports after the commencement of the Tagul Dam project, which was done in 2013, when in fact the proper procedure should have been to approve the SCIA report and the trap report, and then subsequently the commencement of the Tagul Dam project. Instructing solicitor, please revert back to the closing. Yang Arif, you've also named the state government of Sarawak as party here because based on Section 5 of government proceedings. Sorry, Yang Arif. Can you hear me, Yang Arif?
I think my learned brother, Tuan Justice Muhammad Faizi, is a bit, the connection is a bit iffy.
Okay, we shall wait for him then. Shall we wait for them, or should I proceed, Yang Arif?
Is anybody else frozen? I think Justice Azhar is fine. It's just Justice Faizi. I think you can carry on while he tries to re-enter. I think he's moving slightly.
Everyone?
Yes, Justice Faizi, you're back?
Hello?
Yes, Yang Arif. We can hear you now. May I proceed, Yang Arif?
Hello?
Yes, Yang Arif, we can hear you.
I think you can carry on.
Carry on, yeah. Okay, thank
We're
you.
also naming the fifth defendant, which is the state government of Sarawak, as a party in this dispute, because Section 5 of the Government Proceedings Act provides that where an agent of the government is carrying out his duty under the instruction of the state, the government shall also be held liable in tort. Subsequently, for the next issue, Yang Arif, whether the first and the second defendant have the duty to consult the second plaintiff community in regards to the SCIA and the trap report. Yang Arif, the defendants in the present dispute have a duty to consult the second plaintiff because he's one of the parties who are foreseeably affected by the Tagul Dam project. Yang Arif, the defendant should have taken due care and practiced due diligence in ensuring that they've taken all the parties into consideration when they perform the SCIA and the trap report. The second plaintiff, Mr. Saleh, relies on the Sungai Burung as a primary means of subsistence as well as an economic activity. However, the first defendant and also the second defendant have completely neglected him from their studies under the SCIA report and the trap report. And this shows that the first and the second defendant have been completely negligent in carrying out their duties with regards to the community that might be affected, as well as the environment as a whole. Next, on issue 7, whether the first defendant can be held strictly liable for the losses and damages. In order to prove strict liability, we're referring to the case of Abdul Aziz bin Awang and Tenaga Nasional, where the court was relying on the ruling of Relied against Fletcher, where there must firstly be an object that can cause mischief. In the present dispute, Yang Arif, the object that can cause mischief is the water impounded in Tagul Dam. Now, the first defendant has released the water in the Tagul Dam, and subsequently it has caused damage to the plaintiffs. Yang Arif, therefore, since we have fulfilled all of the elements listed under Relied against Fletcher, the defendant should be held strictly liable. Yang Arif, I would like to address the defenses that were raised by the defendant with regards to the other projects that were being carried out. Yang Arif, the Hill Resort, as I've pointed out during my cross-examination, is built on top of a mountain. In addition to that, I've also pointed out to the court, in the SCIA report, it specifically states that the defendants are the one who are building the access roads, as well as the Tagul Dam and the power station, in relation to the Tagul Dam itself. Yang Arif, in relation to the building of the Tagul Dam, they've cut down the kabang trees. They have failed to perform desiltation processes. They have also failed to plant vegetation. Since they have not taken any measures and they're only relying on mere denial and deflecting the blame to other parties, we humbly submit that the defendant should be held liable, strictly liable, since we have proven all the elements under the ruling under violence against Fletcher. Next, issue 8 and issue 9. Whether the first defendant was in breach of legitimate expectation, whether the two new households should be considered. Yang Arif, based on the case of Daraman, the defendants here have made a representation that is clear and unambiguous to the plaintiffs. The plaintiffs have relied on that representation and they have subsequently faced a deprivation to their lives. On that representation and they have subsequently faced a deprivation to their lives. Yang Arif, this shows that the requirements to invoke legitimate expectations that is enshrined under Daraman has been fulfilled. And as such, they should be held liable for the breach of the legitimate expectation. Held liable for the breach. Please scroll down to the next issue. Based on the principle of res ipsa loquitur, it is stated that the burden of plaintiffs is not to prove conclusively that the defendants are the main cause behind the flood. We are relying on the case of Abdul Aziz bin Awan and Tenaga Nasional Berhad. Instructing solicitor, can you please highlight it was not necessary, there should be positive proof? Yes, based on this, it is provided that the burden on the plaintiff to rely on the principle of res ipsa loquitur, we do not have to prove conclusively that the defendants are the direct cause behind the flooding and the damage suffered by the plaintiff, but rather the burden is that we have to prove on a balance of probabilities. Yang Arif, it is our position today that since the defendants have not given any logical, credible answer to why there's a flooding and how the plaintiffs may have been devastated, we submit that there has been no rebuttal to our argument that they are the main cause behind it. And as such, we have proven our case on a balance of probabilities. Yang Arif, before I conclude my submission, I'd like to address the damages that the plaintiffs are praying from the court. Instructing solicitor, please scroll down. Yang Arif, we are praying for an adequate compensation amounting to 2,709,000 ringgit, and we have reached this figure based on the case of Adong bin Kuau and the Kerajaan Negeri Johor, where it was stated that the number of years of 25 years should be multiplied with the number of individuals in the Aborigines settlement, multiplied by the average income of the Aborigines. Now, in that case, the court awarded a total of 26.5 million ringgit in compensation. Based on our calculations that we have performed using the same formula in this case, we have calculated an adequate compensation amounting to 2,709,000 ringgit. Finally, Yang Arif, we pray to the court that the court awards the general damages in the amount that the court sees fit, based on the yardstick provided in Adong bin Kuau and Kerajaan Negeri Johor, where the long-term scale of the effects of the flooding should be taken into consideration. With regards to
is there any appeal for case of Adong Kuau?
No, Yang Arif. The case ends at the High Court. There's been no appeal to the Court of Appeal.
Thank you.
Much obliged, Yang Arif. Yang Arif, subsequently, with regards to the aggravated damages, instructing solicitor, please scroll down. We are requesting aggravated damages for the plaintiffs as well, because the damage suffered by the plaintiffs was exacerbated and caused by the conduct of the defendants. Now, throughout my submission, as well as the testimony of the plaintiffs, we have seen that the conduct and the negligence of the defendants are the ones that caused the flooding. They have not performed the desiltation. They have not planted the vegetation. They've also not taken the due diligence to take into consideration the effects that it would have on the plaintiff's community. And as such, the plaintiffs we submit are entitled to aggravated damages. Finally, Yang Arif, we also submit that the plaintiffs are entitled to exemplary and punitive damages, because the defendants we submit have acted with complete disregard to the rights of the plaintiff. Particularly, Yang Arif, I would like to point out to the fact that the defendants have completely, throughout their testimonies, repeatedly stated that the plaintiffs are not natives and are not indigenous people. They have admitted to indigenous people, but they have completely omitted the detail that we are native and we are entitled to native customary rights. Yang Arif, this is a blatant disregard to rights enjoyed by the plaintiffs as the Aboriginal people, which I have illustrated under our Federal Constitution's Article 161A, as well as Article 5, Article 8, as well as Article 13, Yang Arif. Yang Arif, that concludes the closing submission for the plaintiffs. Much obliged, Yang Arif.
Yang Arif, do I proceed with my closing submission?
Yes, proceed.
Much obliged, Yang Arif. May it please the Honourable Court, the first defendant, Borneo Electric Berhad, BEB, herein presents closing submission for the case. The defendant submits 13 points for the closing submission, which is the first one will be submitting on the plaintiff failed to prove the elements of strict liability. Secondly, on the native rights of the plaintiff. Thirdly, will be submitting on the defendants did not breach the fundamental rights of the plaintiff. Fourthly, on the incurable defects. Fifthly, on the remoteness of damage. And will be raising the equity maxim on he who comes in equity must come in clean hands. And the plaintiff have a strict burden to prove the allegations made against the defendant, and also on the matters of the absence of the maker, and also will be raising 4 defense instead of 3 as mentioned by my learned friend just now, which is the first one will be raising the defense of consent of the plaintiff, the act of a third party, statutory authority, act of court, and common benefit. With that, I will now proceed with my submission. Oh, and in this submission, the first defendant will also provide legal responses to the arguments made by plaintiff. Yang Arif, moving on to my first point, which is that the plaintiff failed to prove the elements of a strict liability. Yang Arif, in order to prove a strict liability against the first defendant, plaintiff community need to prove that all elements under strict liability, in which are the existence of a dangerous thing, that the first defendant purposely accumulated the objects, and there is an escape from a place where the first defendant has control over, and there is a non-natural use of land, and that the damage was caused consequently by the defendant. We humbly refer the case of Abdul Aziz Awang or Muhammad and others at Tenaga Nasional Berhad 2007, where in this case, it is provided that the water release from the defendant's premise was the correct decision to avoid a massive flood and cause widespread destruction to properties and loss of life. Necessary measures have also been taken by the defendant, hence res ipsa loquitur is inapplicable in this case. Yang Arif, if I humbly pray to direct the court's attention to the map which is tendered by my learned friend just now, which is on the map after the Tagul Dam project commenced, where in this present case, the first defendant has taken all necessary requirements to avoid the bigger danger to the community living around the Tagul Dam, Yang Arif, in which includes we built embankments 2 km after the Tagul Dam. And this is to prevent the flood. And this is also the first time that the flood happened, as Kenyalang recorded the highest rainfall in decades. The last time such heavy rainfall happened was in 1970s. And this is the first time that the flood happened. And we also have built this embankments, and the damage was not even caused by the defendant in the first place, neither it is consequently caused by the first defendant throughout the years, as there has been increasing development along the riverbank upstream, and there is also a logging concession next to the first plaintiff community resettlement area that is not under the first defendant's duty. And now moving on to the second point, which is on the native rights of the plaintiff. Yang Arif, we submit on, if we may refer on section 5, clause 1 of the Sarawak Land Code, which provides that no recognition shall be given to any native customary rights over any land in Sarawak created after the 1st January of 1958. Yang Arif, in the current case, we acknowledge that the plaintiff are native, however, they have no customary rights over the land, whereas they failed to prove that they have established permanent dwellings in the respective communities. And the first defendant established their dwellings in 1965, while the second defendant established their dwellings in 2005. This is acknowledged under the Sarawak Law Ordinance. And the land occupied by the plaintiff was not statutorily declared that it is a native right, and ignorance of law is never a defense, Arif. So now, moving on to the next point, which is on the defendant did not breach the fundamental rights of the plaintiff. Young Arif, the plaintiff raised the issue on whether the plaintiff is entitled to compensate and or damage for the loss of livelihood pursuant to Article 5+1 and Article 8 of the Federal Constitution. We would like to reaffirm the court's attention that every project that involved the first defendant and the plaintiff are sufficiently compensated on mutually agreed terms by the parties involved. Therefore, the first defendant has never denied the plaintiff rights, Yang Arif. We acknowledge the plaintiff right under the Constitution. However, every right listed under the Federal Constitution is subject to limitation, and the first defendant acknowledge that every Malaysian citizen has the rights pursuant to Article 5+1 and Article 8 of the Federal Constitution. However, if the plaintiff wish to and believe that they are entitled to be compensated for the loss of livelihood, they have the burden to prove all the elements required, which in this case they failed to prove, Yang Arif. Now, moving on to the next point, which is on the incurable defects. In the case of Commissioner for Labour Klang on behalf of Apaturai and the Manager Cargo Handling Corp Limited 1953, in this case, it is held under Order 20, Rule 5, where the defendant has not misled by the misdescription. And the question that needs to be considered is whether the proceeding issued is against someone who can properly describe as non-existent. Yang Arif, I pray to direct the court's attention to the cover page of the statement of claim made by the first plaintiff, and I compare it to the table provided in the case scenario, where it is provided that the first plaintiff is filing a claim on behalf of 258 native of Long Burung in the statement of claim of the cover page. However, we only acknowledge that there are only 250 native of Long Burung, and we only acknowledge that there are only 250 native of the Long Burung Baru that we resettled in the new Long Burung Baru. And despite it can be curable under Order 2, Rule 2 of the Rules of Court 2012, however, in this case, the defects are too severe and that they cannot be cured as it will cause injustice to the first defendant. Now, moving on to the next point, which is on the remoteness of damage. Yang Arif, the general principle here is that the damage cannot be too remote from the actual breach of duty. We are looking for the consequences that could be in the reasonable contemplation of the defendant. If I may refer to the case of Overseas Tanship Limited and Mort Stock and Engineering Co., where in this case, the Privy Council held that the defendant is not liable, as a reasonable man could not possibly have foreseen the wharf would be damaged in the way as a result of the defendant's act. Yang Arif, I pray to direct the court's attention again to the map tendered by the witness, my learned friend just now. The Long Curry is too remote from the Tagul Dam, as you can see here. The Tagul Dam project with Long Curry, the distance is about 6 km. While the three affected communities that we resettled, which is the Long Curry, Long Burung, Long Tarat, and Long Tagul, is situated within the 500 meters from the Tagul Dam project took place. The flood is unforeseeable in the first place, as if it is foreseeable, Amasara would never be considered as an option for us to resettle the first plaintiff. Therefore, the distance of Long Curry from the Tagul Dam is too remote from the cause of action. And on the sixth point, we would like to raise on the maxim of he who comes in equity must come in clean hands. Yang Arif, in order to bring the case, the plaintiff must come in clean hands. However, in this case, the plaintiff did not come in clean hands, as there is nothing much that the defendant could have done to reduce the flood, and it was due to the heavy rain. We have made various consultations before the resettlement, and the first plaintiff have agreed and chosen Amansara as their new resettlement area, and they even rejected the aid that we offered to give them after the flood happened. And the defense counsel also have misled the court by submitting a different witness statement instead of the witness statement that they provided to us. The instructing solicitor, if I pray to the court to direct the court to the differences between the witness statement that was tendered in the court today and the witness statement that we received, that the defendant received by the plaintiff.
Yes, please give me a moment. Is it sharing? Is it visible to the court?
Yes. Thank you very much, interesting solicitor. Instructing solicitor, if it's possible, could you please zoom in on the screenshot that you took?
I am paralleling both. This is the witness statement that were tendered, and this is what we were served.
Mr. Blash, Yang Arif, as you can see here, there are slightly amendments made to the witness statement tendered, given to us and also tendered to the court today. Hence, Yang Arif, we submit that it has misled the court and it also have not give us a chance to defend ourselves. And Yang Arif, we submit that the other two taguls, which are tagul Long Tara and also Long Tara and Long Tagul, who were affected along with Long Burung to resettle in a new place, they got the same compensation and resettlement package, but however they can still survive and they have never raised any claim or complaints with the resettlement plans that we gave them. And this proves that actually the first plaintiff don't know how to spend the compensation that we give them wisely and accordingly. And next, moving on to the next point, which is on the plaintiff have a strict burden to prove the allegations made against my client. The allegations made by the plaintiff on the illegality of the project is a serious illegalization and malicious in nature. However, up until today, there is no proof that the project is obtained illegally by our client. And if it is obtained illegally, then the plaintiff in the first place should have reported the matter to SPRM. And as for the allegations on the money given by BEB to the first plaintiff is received inconsistently, the plaintiff has a strong burden to prove as the only complaint made by the first plaintiff. However, other affected communities such as Long Tara and Long Tagul have never raised any concern regarding the pay. And as long as the payment is made monthly, then BEB has never breached any promises that we promised the first plaintiff. And next, on the 8th point, which is on the absence of the maker, if we may refer, I pray to the court to refer to Section 73A, Clause 1, Clause B of the Evidence Act 1950, where in this case, where in this provision, in any civil proceedings where direct oral evidence of a fact could be admissible if the maker of the statement is called as a witness in the proceeding. We humbly submit that to the court that to put in record that the defendant has never received a new witness statement by the plaintiff. And we would also like to put into record that the learned plaintiff has failed to call the maker of the document, thus the authenticity of the said document is questionable. The defense counsel has also misled the court by submitting that they have tendered the same exact witness statement that was shared to the judges. And for example, we humbly pray also to refer, to direct the court to refer to D9, which is tendered by us just now. I mean to the exhibit P7 of the table by fisheries, where in this case, the plaintiff tendered the table despite he is not the maker of the table, and the maker of the table is actually from the Department of Agricultural Sarawak Inland Fisheries Division. And there should be no element of surprise, and this has caused the defendant unable to prepare a proper answer and defense. Next, we would like to defend the allegations made by the plaintiff towards our client. We would like to raise our first defense, which is on the consent made by the plaintiff for the resettlement. Yang Arif, we humbly refer to the case of Relied and Fletcher, where it can be concluded that the express or implied consent of the claimant to the presence of the source of danger, provided that there has been no negligence by the defendant will be a defense. And in this case, Amansara as a place of resettlement has been impliedly consented to by the first plaintiff community by the new resettlement to Amansara in July 2017, despite another option is also given. And the resettlement gave more benefit than harms to the first plaintiff community, as it is easier for the first plaintiff to commute to clinics, schools, and markets, And to say that they are forced out of their dwellings would be unfair to the defendant, as they have received compensation monthly and even moved to the new long. And first plaintiff was also given two options before the resettlement, and the late Tuai Helang chose Amansara instead of Kampung Melora because of the strategic area, and hence the first plaintiff was never forced to move. Their current action is as if the action was made due to their afterthoughts. Next, moving on to the second defense of a strict liability, which is on the defense of act of third party. Yang Arif, the test used to determine whether a person is a third party is to whether that person is outside the defendant's control or whether the act of a third party is unforeseeable by the defendant. If none of this is applied upon the defendant is not liable for the damage. In the case of Parks and Job 1879, the court held that since the sequence of events were not foreseeable and the defendant was not negligent, the defendant was not liable. And if in our current situation, there is a third party that contributes to the flood, namely the development along Sungai Burong downstream from the dam, and also the activities including logging and road construction and a future hill resort. The logging activities resulted in erosion, causing mud to flow down from the highlands during rain, eroding hills and destroying the water catchments, and causing the lowlands to become flooded. And the fact that the acts of the third parties are unknown to the first defendant, the logging companies are beyond the control of the first defendant, has dismissed the liability of the first defendant to be responsible to the damage. We humbly submit to this court that the act of a third party is beyond the defendant's control and is unfair to the defendant to take liability for the actions of the third party. Next, we would like to raise a defense against the allegations made of strict liability, which is under the defense of statutory authority. In this case of Kuala Lumpur, Kelang and Port Swettenham Omnibus Co. Berhad and Transport Workers Union 1971, the principle in this case provides that Section 2 of the Industrial Relation Act 1967 defines statutory authority as an authority or body established, appointed or constituted by any written law and includes any local authority. Thus, in this case, my client has been appointed by the fifth defendant, which is the state government of Sarawak, making him to be working under the authority that was given to him. Any liability shall exclude the first defendant, and any consequences which causes the damage, my client shall not be held responsible and liable over the damage, as the first defendant has been fulfilled. The duty of the first defendant has been fulfilled. Moving on. Now I pray to direct the court's attention to the document 1 under project description, which is regarding score. It is unfair to say that the defendant did not thoroughly research before making the Tagul Dam project. If you can see here, before the fifth defendant decided to proceed with the Tagul Dam project, a thorough research has been made through the Sarawak Corridor of Renewable Energy, which is SCORE. And this is a thorough research. And now, moving on to the next defense, which is on the damages happened due to the act of God. It can be seen in the case of Blythe and Birmingham Waterworks Co. that there was an unprecedented severe frost. Pardon me, Arif, if I may drink a sip of water.
Yes, please.
So that's Arif. All right, moving on. It can be seen in the case of Blythe and Birmingham Waterworks Co. 1856, where there was an unprecedented severe frost that year, causing the pipes to burst, result in severe damage to the plaintiff property. And it was held that though the frost is a natural phenomenon, the occurrence of an unforeseen severe frost can be attributed to an act of God, thus relieving the defendants of any liability. I pray to direct the court attention to Table 1 for the historical flood event at Amansara from January 2020 to February 2021. Young Arif, in this case, as we can see here, because of the heavy rain that was forecast throughout the month of December and into January, we had to release the water from the dam. And this is a normal practice. And we do not believe that it is sole or real cause of the Amansara flood. And the catchment area and reservoir also act as a flood control measures. This action did not exonerate a negligent conduct of the defendant, but more towards the unavoidable and beyond the authority of the first defendant. Lastly, we will also raise that the heavy rainfall was truly out of power to control, as it is an act of God. So now moving on to our last defense, which is on the common benefit. Yang Arif, the common benefit is the act of common benefit is allowed in order for a person to conduct a dangerous thing if it is for the common benefit and interest of the public. And in the event that there is damage arising from the said action, the defendant will not be held liable under the defense of common benefit. And in this case of Carstars and Taylor, the court held that even though the water was disposed as of dangerous, the defendant was not liable as the act was done for the common benefit of both parties. And in our current station, the act of releasing the dam by the first defendant was made for the common benefit of the defendant, as it is to mitigate from any further server situation to happen from any server flood to happen. And this is to mitigate from a greater damage. And the first plaintiff has also received various benefits from the resettlement, such as receiving an income of 900 ringgit per month, despite the earnings of 35 ringgit only previously in their previous resettlement area. And it is also closer to essential services such as schools, clinics, grocery shops, and other basic necessities. And therefore, the resettlement plan benefited the plaintiff, especially in medical necessity, prior to the resettlement, and the community rely on a fly-in, which they used to rely on a fly-in doctor at least every once in 6 months at Long Burong. And now they can just go to the clinics, which is only 30 minutes away. So in conclusion, Arif, the first defendant humbly submit that the plaintiff have failed to prove a prima facie case. Plaintiff was not able to prove all the allegations made by the first defendant, and therefore the first defendant humbly prays to this honorable court for the claims to be dismissed. Much obliged, Yang Arif.
Okay, thank you very much. That is the end of the session, right?
Yes, Tuan.
I think Yang Arif, you're muted.
Justice Faizi, you're muted.
Sorry. Okay, thank you everyone. So we will come back in 5 minutes with our decisions. Where's the committee? Can you assign us to the breakout rooms?
Yes, Tuan. We will be directed to your breakout room shortly.
Yes.
Judge may enter to breakout room as assigned.
Now, good afternoon, everyone.
Good afternoon, Yang Arif.
Good afternoon, Tuan.
Okay, we have our decision at the moment. But before announcement of the result, we would like to give you tips and comments so that the winner can improve in the next round. I suppose the next round would be the finals. So we would like to have a very good quality finals. So you can get the advice and tips from the judges lah. So on that note, I would like to invite Puan Hajar dulu untuk bagi a few comments and observations.
Okay, terima kasih Faizi. Hi everybody, I see some familiar faces, some new faces. Congratulations first for making it to the semi-finals. It's been a pleasure to judge you. Just a few quick comments. I think I'll put it into 2 points. So procedurally, what usually happens, I think this is for the plaintiffs' counsel, we don't mark the witness statement as an exhibit. We actually mark it as WS1 or something like that. So witness statements are rarely marked as an exhibit. So that's, I think, is a procedural error that you need to take note of. Exhibits are exhibits, which are documents. So I have to point that out, number one. Number two, you know, in cross, I think you've done it pretty well, most of you. I think I was quite impressed. But for cross, you know, you have to putting something to the witness and then agreeing or disagreeing. So there's a flow, right? You ask a question, you flash a document and ask a question. If they disagree to something, then you put it to them, the notion that you want to put forward. You don't terus cakap, I put it to you something, because then where does that come from? Right, when I started out, I did exactly the same thing, and I was scolded by many judges. I think belum lagi lah Tuan Azhar masa tu, tak sempat nak marah saya kot. But I mean, there's a flow to how things are done. So you ask a question, if they disagree with you, then you put it to them what it is that you want to put to them. You don't put it straight away, right? So that is something you need to take note of in your final rounds, whoever that may be. But other than that, I think it's okay. And congratulations once again. That's it from me, Faizi.
Alright, thank you Puan. Tuan Azhar, please.
Okay, dah lama kita ni, tahniah semua lah. To speed up the matter, saya dah teliti statement of claim kan. So statement of claim, sorry I speaking in Malay cepat sikit lah. So statement of claim, please bear in mind bila kita buat statement of claim tu, kita buat satu sequence saja. Jangan up and down cerita. So bila up and down tu kita jadi confused. Lepas tu bila you determine what you want to dalam statement of claim. Remedies, what remedies. And then rasa remedy yang besar you'll put in the first place. And then ada remedy. Okay. So saya tengok dia punya plaintiff punya remedy ada minta injunction lah. So injunction tak boleh pakai lah sini. Kena ingat lah, injunction ada specific provision untuk injunction. So that one I do not comment lah. Okay. So statement of defense saya teliti. Statement of defense memang defense they deny everything, every single paragraph defense deny. Ada apa ni, ada jawapan for rebuttal untuk defense lah. Okay. For line of questioning terutama untuk cross lah, pasal kita sekarang ni kita ada witness statement baca dalam mahkamah saja. Bila cross, seperti yang saya cakap tadi, bila cross, kalau you want to rely on jawapan yes or no, please be extra careful. Sebab bila jawapan yes or no tu might be go against you. So before you ask the question, you kena tahu, you boleh presume apa jawapan. Kan? So janganlah tanya soalan-soalan yang kata banjir disebabkan apa? Of course lah, banjir disebabkan oleh air. Kan? So be precise lah. Jangan berkelahi dengan saksi. Itu yang paling mustahak, kan? So yang jadi saksi ada pengalaman, yang you pun ada nak cross, nak re pun ada pengalaman. So itulah actual yang berlaku di mahkamah. So kena sabarlah. So sekarang ni kita online hearing, lagilah payah online hearing. So hiccup there and then, apa benda hiccup kan. Okay. One more thing, when you ask the question or when you put your submission, please see your judges. Please see your judges, sebab kadang-kadang judges ni manusia juga. Judges ni dia off tangent. Dia pun ada benda yang dia mungkin masa tu dia concentrate hal dia masa on the bench. Dokumen yang dia rujuk tak sama dengan you punya dokumen masa berbicara. Mungkin ada dia punya mind tu ada lingering on something else. You kena put the judges on the right track. Otherwise, you your own, judges their own. Kan? So, yang ni memang tak ada, school of law tak ajar benda ni. Know your judges, know character of the judge. Kan? Kadang-kadang saya nak kata kadang-kadang judge ni dia ada hari-hari dia, tapi bukan semua, kan? Tapi you kena tengok concentration of the judges pada masa you buat case tu. Okay? Satu lagi, line of questioning, jangan terlalu monotonous. You kena angkat suara sikit, ada mellow down, mellow up dan sebagainya lah, kan? Jaya kadang-kadang you punya soalan bagus, tapi kadang-kadang you little bit monotonous, kan? So saya percaya you boleh jadi seorang peguam yang bagus, begitu juga yang lain lah. Dan Najat dengan Batrisha, 2 kali saya dah bagi tahu tadi, bila cross jangan expect yes or no, yes or no, yes or no. Okay? So tadi saksi siapa tadi? Saksi defendant pertama. Itu karakter sebenar saksi defendant pertama. Saksi defendant yang cuba mengelak soalan yang saya tak dengar. Tapi PW1 PC1 can handle this saksi well. PC1 tidak off tangent lah, dia boleh control dia punya decorum dia, kan? So gitulah, bila di mahkamah kita nak tengok saksi-saksi itu sama ada saksi itu inline dengan kita ataupun sebagainya. Tapi yang penting saksi yang datang mahkamah, peguam yang datang mahkamah, we work for justice. Itu menang kalah itu terpulang, tapi kita jangan create evidence. Okay, thank you very much.
Alright, thank you Tuan. Okay, from my observations, very short, sekejap. The reason why we conduct trial is to call witnesses and to extract information from the witness. Okay, so you all dah ada documents, all the documents, case scenario dah ada. So what is your case? Your case is all about breach of duty. For example, plaintiff, how do you extract that from the witness? That should be your focus. If the your defense is act of God, how do you extract that defense from the witness to support your case? You want the other side witness to agree with you, which is your defense. You want the plaintiff witness to agree that this happened because of act of God. So you must put forward questions that can support your defense case. Yes or no question, macam Tuan cakap tadi. Problem with yes or no questions is this. Once you ask yes or no question, the witness answer no, you're stuck. You cannot elaborate further than that. You cannot expand your questions. Okay, so yes or no question is good in circumstances where even the witness cakap yes pun kena, the witness cakap no pun kena. For example, I bagi contoh yang tadi, masa expert witness, saya tak ingat siapa tanya soalan, Jaya ke? Dia tanya, okay, this is your own, this is your own EIA review. Obviously EIA tu cakap ada erosions. So that in that circumstances, you tahu dah, dia jawab yes pun kena, dia jawab no pun kena. So you can give yes or no question kat situ. Sebab kalau dia cakap no, it will be conflicting dengan dia punya stand. Kalau dia cakap yes, dia akan concur dengan you punya suggestions. So you must know how to play around with yes or no questions. Now, satu lagi saya notice, when you re-examine, you don't reintroduce more evidence. Sebab bagi saya, re-examine ni, kalau you kena explain banyak, that means you're not doing a very good job in EIC. Okay? Re-examine, it should be precise to repair the damage done by cross-examinations, not to reintroduce, realign your facts. No, don't do that. Okay? Okay, for the purpose of final ni akan judges macam saya dapat tahu mungkin Tun Richard, former Chief Justice, former Chief Judge of Sabah Sarawak, Chief Judge of Melaya, and Chief Justice pun akan ada. So these justices, they expect more on merit rather than technical. Okay, janganlah terlalu contoh macam tadi awal tadi kita dah spend about few minutes on isu tentang map semua tu kan, revise map. Benda tu terlalu technical yang saya rasa you boleh tidak memberikan apa kecuali your advocacy lah, kan. Try to minimize on the objections and objection. Okay, leading question. Satu lagi saya duk tengok, you suka lah, this is leading. Leading ni bila dia suggest answers. Tapi ada soalan-soalan yang dia nampak macam leading tapi dia tak suggest answer. So janganlah terlalu rigid on that procedure. Satu lagi objections. Okay, objections, when you want to object, you must have basis. Sama ada this objection based on hearsay, these objections, the question is unpleaded, based on unpleaded facts ke, kan? You tak boleh object for the sake of objections. Okay, so try to minimize and research on this, how to improvise, how to improve your skills and advocacy punya area in this area for the purpose of finals. Okay.
Faizi, I just nak tambah.
Yes, please.
Okay, for submissions, guys, you know you're flashing your submissions, right? You are reading it at verbatim.
Betul.
Please do not do that. I mean, we've already read. Like Encik Azhar tengok saya tengok Tuan Azhar, saya tengok Faizi. I mean, we're looking at each other. I mean, it would be great because we've already read your submissions. The written skeleton submissions are there. It was given to us. We read it. Why don't you just summarize? You can say, my lords, my lady. I have prepared a skeleton submission. It is before my lords and my lady. I will just summarize 13 points that I have in maybe 10-15 minutes or less. Wouldn't that be great? Because like Tuan Asa was saying, sometimes we go off tangent, you know. You're talking about something, we have go off to Disneyland or Legoland because it is really too long, and we know you are reading, so we don't bother. So maybe you could summarize whatever you have stated in writing. So that's all lah, I think. Thank you.
Betul Puan. Sebab macam tadi submission kan, there are certain points yang macam dah obsolete dah tak ada, it's not an issue anymore, but you still read that, you still highlight that. So in submissions, final submission, you must pick up your strongest point and lump sum and rebut the other side simultaneously.
Sorry lah, we're being so particular because this is semi-final, right? You're going to
This is semi-final and you're going to
judges
final,
even
so we
the
expect
judges
more.
masih-
Kita tak nak
dia orang
nanti
judge
all
ni kan,
among depan judges nanti depan Chief Justice tau, Tuan Tengku Maimun.
Tuan Azhar dia member relax sikit. Dia
Kita nak you, okay?
One more, I think, Mr. Chairman.
No, yes, Tuan, no problem.
Yang statement of claim kan, saya baca, you have first and second plaintiff. But then what the remedy for second plaintiff saya tak jumpa. Apa yang second plaintiff nak?
pun tak ada, memang tak ada.
Tak ada kan? So tengok balik lah. You check balik. Tengok balik kan. Second plaintiff tu you minta.
Sebab tu dia orang tadi pun tak fokus dalam ni, dia orang pun tak tahu dia punya you punya structure kan, dia punya tiang rumah tu pun tak betul. Jadi rumah tu sekali kena angin, goyang-goyang. Alright.
Okay.
Are we ready for the results?
Thank you very much.
Okay, result. Saya pergi kepada bawah dulu. Best overall performer adalah Defendant Counsel number 2, iaitu Nur Nisa Batrisha. Okay. Kemudian Best Counsel adalah PC2, iaitu Plaintiff Counsel number 2, Jaya Ganesh. Best Witness adalah DW2, Siti Nur Anisha. Best Instructing Solicitor adalah Plaintiff Instructing Solicitor. Dan winner untuk semi-final di antara Multimedia University melawan Uniza dalam civil case di antara Jaha Kabis and another against Borneo Electric Berhad. The court would like to announce plaintiff has proven their case on the balance of probabilities and the winner is MMU. Alright, congratulations to the winner and also congratulations to Niza for giving such a good fight and to the winner. And thank you all. Have a nice weekend, everyone. Thank you, Tuan Azhar. Thank you, Tuan Iza, for your time.
Thank you, Tuan.
Thank you, Tuan.
Thank you,
Okay, thank you. Tahniah semua.
Everybody, congratulations.
All right.
The next
All right, thank you very much. That marks the end of our session today. Thank you very much to all the contestants and the honorable judges for your time and effort for today.
Ada yang ambil gambar ke?
Boleh. boleh.
Kan Belly akan screenshot kan. Belly tak nak buka pun video dia